Okay, it is now 6 o'clock. I've heard the bell chime, and the atomic clocks on our computers have caught up. So this is Robert Depper. I'll go ahead and call to order the Burlington Police Commission. And the first order of business is a roll call and determination of quorum. I will start online with Commissioner Cox. Could you please indicate your presence?
I'm here.
Okay. Commissioner Genorio?
Here.
Commissioner Paul? And Commissioner Fass? Okay, we have a quorum. So first item would be additions or modifications to the agenda. Are there any of those?
Can I propose a modification?
Sure, please.
To move item 5.3 up to 5.1.
Sure, I will second that. I don't have a problem with that. All those in favor, please say aye.
Aye.
Aye. Those opposed? Okay.
I'm sorry, did you want me to read what that was?
No.
Okay.
I had another question about
Okay.
the agenda.
All right, well, I'll do that again. I know Commissioner Genorio and I voted for it. Commissioner Fass, were you? Oh, that's okay. Are you in favor? Yes. Okay, all right. Commissioner Paul?
Yeah, it's fine with me.
Okay. And Commissioner Cox? Commissioner Cox, are you in favor of that modification or no? I'm sorry, Commissioner Cox, you're muted. We can't hear you if you were speaking. Okay. Well, at this point, the ayes have it, so we will move 5.3, fair and impartial policing policy, March 11th NICE operation community organizations discussion to 5.1. I will also make a motion to modify the agenda. We currently have an executive sessions on 8.1. In talking to the city attorneys today, and this is my fault, I didn't put sufficient information in that executive session for the modifications that happened to open meetings law in the statutes, so I'm going to go ahead and move to just take that off tonight. Do I hear a second?
Second.
Okay. All those in favor, please say aye.
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 Aye. Okay. Motion carries. That will be taken off the agenda. The next item is the motion to adopt previous meetings minutes. I will go ahead and so move. Do I hear a second?
Can I make one proposed alteration first?
Certainly.
In the fourth paragraph of section 4.1, if we could replace Commissioner Genorio agrees with understands the chief believes, or something to that effect.
Okay. I don't have a problem with that. Does
Okay.
anybody else? Is there any discussion on that? Yes, go ahead, Commissioner Paul.
Thank you. First of all, we haven't voted on the agenda yet. We've only voted on modifications to the agenda, so we haven't voted on the agenda. Commissioner Finneran has been trying since 6 o'clock to get on, and she does have something to add that's germane to the agenda. So I will send her the link again, and if we could just hold off for just a moment.
Sure.
Okay, it appears they're both able to get on now.
It does
Okay,
appear that way.
I apologize. Thank you for your patience.
Sure. Commissioner Cox, I see your hand is up.
Yes, I'm not sure if perhaps you didn't see the email from Haley, but Haley had asked that we put off item 5.3 until we meet at perhaps a special meeting in early May.
Okay, you're asking to modify the agenda to take 5.3, fair and impartial policing policy regarding March 11th, the ICE operation community organizations discussion off the agenda?
Well, that's what Haley had asked us to do.
I
So,
didn't
I
understand.
don't know if you didn't see the email or not, but.
I
can
did
we
see the
discuss-
email. I did see the email. I did not read her email that way. What I understood the city's attorneys to be saying is that something that we all are very well familiar with, that we shouldn't be discussing otherwise confidential matters in a public forum, and that the appropriate forum for that would be the executive session. And so it is, I would understand, and in talking to the commissioners, I don't understand that we will be discussing any confidential information in that fair and impartial policing policy regarding March 11th ICE operations for community organizations discussion. Go ahead. Go ahead, Commissioner Cox.
So perhaps you're looking at a different email from me, but in the one that I got, that I'm looking at, she had specifically said that to put off this discussion of fair and impartial policing till a different day.
Okay, are you moving to do that?
Yes.
Okay, is there a second?
I'll second.
Okay, Commissioner Paul seconds. All those in favor, say aye.
Aye.
Commissioner Paul?
Aye.
Commissioner Cox? All those opposed?
Aye.
Nay.
Nay. Okay. Motion does not carry. That will remain on the
It's three
agenda.
to- Is it, how many is it?
I believe that was,
I don't know what Commissioner Finneran voted.
okay.
Yes, she did.
Commissioner Finneran, what was your vote on modifying the agenda? Were you a yes to
Aye.
modify? I'm sorry?
My vote was yes.
Your vote was yes to modify the agenda?
Yes.
Okay. And Commissioner Fast? You want to take off fair and impartial policing?
Sorry, I want to leave it on, and I wonder if Commissioner Finneran is thinking the same.
Okay, I'll do this again. Okay, so I understand at this point, there is a motion by Commissioner Cox to remove 5.3, what is now 5.1, the discussion of fair and impartial policing policy, to take that off the agenda. That is the motion. Commissioner Paul has seconded that motion. All those in favor, I'll just poll. Commissioner Cox, are you in favor of this modification?
Yes.
Okay. Commissioner Janorio, are you in favor of this modification? No. Commissioner Finneran, are you in favor of this modification?
Yes.
Okay. Commissioner Paul, are you in favor of this?
Yes.
Okay. Commissioner Fast, are you in favor of the modification?
No.
Okay. I am not in favor of this modification. It is split 3-3. I believe the motion does not carry, and this will stay on the agenda.
We haven't made it, no motion has been made to approve the agenda.
Okay. I didn't know, can you direct me to the place in the ordinances or statutes where an affirmative vote in favor of the agenda is required?
It's at every meeting that there's a motion to approve the agenda. Until you approve the agenda, you don't have a meeting.
There has not been a motion ever in the meetings that we have had here to approve the agenda. It has been, we have had motions to adopt the previous meeting's minutes. The agenda was sent out well before this. It was noticed, it was warned, and I received no objection to the agenda.
Actually, you did receive objections to the agenda. There were a number of items that were asked to be taken off. There were changes that were asked to be made. Those are objections to the agenda.
Okay, well, those changes were made for the
Right.
most part. Are you talking about your objection simply to what particular part of the agenda do you have objection to?
I'm not discussing that. I'm saying that in order to have a meeting, you have to approve the agenda.
Well, if you can point me to the statute or the ordinance that requires that.
Well, it's in Robert's rules. If you want to give me some time, I'll look it up.
Okay, we are not under Robert's rules yet.
Well, we don't have a city attorney here. If you want to take a break and we will ask for a city attorney to give an opinion, we can
Well-
certainly do that.
Right now, we're having additions or modifications to the agenda. If anyone has other objections to the agenda, that would seem the appropriate time to do so. I mean, if there is a problem with the agenda, the additions or modifications would be the time to modify that. If you have a motion to do so,
That's right,
please make it.
and then there has to be a vote about whether or not, a vote to move the agenda forward.
And I'm sorry, are you going to, would you like to move to have a vote on the agenda?
I'm
I
fine
didn't
to
think
vote
that I
if that
needed to
would,
do that.
if that would move us forward, I'm fine to just vote, and then maybe we could figure it out after the fact.
Okay, yeah, I mean, if we pass the agenda, we pass the agenda. So would you like, Commissioner Janorio, are you moving to approve the agenda?
I move to approve the agenda.
Okay, I will second that, and I will do a polling. So Commissioner Cox, Commissioner Janorio has moved to approve the agenda with the modifications we have made. I have seconded that. Do you approve of the agenda with the modifications made or disapprove of the agenda with the modifications made?
Disapprove.
Okay, you disapprove of the agenda. Commissioner Finneran, do you approve of the agenda as articulated with the modifications we have made or disapprove of it?
Sorry, what modifications?
We made a modification moving 5.3 fair and impartial policing to 5.1 up on commission business. We also made a modification to remove the executive session. Those are the two modifications that have been made so far. The current motion by Commissioner Janorio and seconded by myself is to otherwise approve the agenda as written. Commissioner Cox is not in favor of that. And what is your vote?
Yes, that's fine with me.
Okay. Commissioner Janorio?
Yep.
I am also in favor. Commissioner Paul?
At the advice of the city attorney, I'm not in favor.
Okay. And Commissioner Fast?
Yeah, I'm in favor.
Okay, thank you. Motion carries. We will continue on with the agenda as written with the modifications as we discussed. Now, the previous meeting's minutes, I don't know
I'm
if
sorry,
we...
what was the vote again? What
You
was
voted,
Commissioner Finneran's?
the vote as polled, it was, I believe, 4-2 in favor of continuing with the agenda and approving the agenda as written with the modifications that we had made immediately previously. Okay. Now, moving to the adoption of the previous meeting's minutes, Commissioner Janorio, I believe you requested, moved, it was seconded to modify the minutes as you had articulated. I believe that passed. Was there any other comment with regard to the motion to adopt the previous meeting's minutes? No further comment. I will move to adopt the previous meeting's minutes with that modification by Commissioner Janorio. Do I hear a second?
Second.
Okay. Thank you, Commissioner Fast. All those in favor, please say aye.
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 It appears to be unanimous. We'll move on, and it carries. We'll move on to the public comment period. We have 10 minutes set aside for this. The public is invited to address the commission. Good evening, Councilor Grant.
Thank you. Mila Grant, City Councilor for the Central District, which is Wards 2 and 3, which is the area of the city that has the most quote-unquote incidents, which, as I'm sure you know, includes a wide variety of things. Many of you know my history, but just in case, I served on a committee, a special committee to review policing policies. I then served as a police commissioner, and then I ran for City Council, where I served on the Public Safety Committee my first year, and then the last 2 years as chair until I was recently removed. I was stunned to find out that initially the request was that I would be thrown off the committee completely. I am the most knowledgeable and experienced person with regards to the public safety issues in the city, especially with regards to how it affects my district. We fought and pushed back because this was obviously discriminatory and it was political AF. I am gravely concerned at the direction. We're already missing a first meeting. So we should have had an April meeting. We haven't. It's been crickets at a really crucial time. It's a really, really crucial time. So it's interesting to me to hear the conversation back and forth about FIP, fairness and impartial policing, because that, quite frankly, was a conversation that this commission should have had a long time ago. Once we knew how ICE was moving through this country and in our region, we should have been having this conversation. And now that March 11th has occurred, you definitely need to be having the conversation, because we need to be prepared for our reports that are getting ready to come out. The letter that you have concerning access to body cam footage, just a quick note, you want to correct the date from May 11th to March 11th, but it's very concerning that you haven't had access yet. The expectation that the public has is that there will be full access available once the reports have been released, and there has been a meeting with the chief and the mayor. I can tell you we are at a crossroads again. We are at a reckoning again. The feeling in our community is similar to the feelings in 2020. Our faith in our police department is really being tested right now. How we respond is important, and now we have political activity that is going on that is meant to stop people from talking. I know that I was being removed because I said once the judges that released the people that were detained said their constitutional rights were violated, that's a question immediately whether FIP was violated. And it needed a conversation as to what we would do differently next time to protect individuals in our community. I will say that we're dividing again amongst marginalized people and the people that are there for them and want to protect them. There's race issues here, there's classism here that are deeply, deeply concerning. They're embedded, and we see what's happening at the federal level coming down to our local government as well. I had a reporter say to me that a fellow counselor said that I was prone to violence. That's like a gut punch. It's profoundly racist. We have someone coming onto the Public Safety Committee who's used the N-word and who has more than once done social media posts and talking to his constituents, advising them that they arm themselves when they shop downtown. You also said that we cannot question police because that makes the police department not trust the Public Safety Committee. It's always about balance. And the last thing I'll say is just to remind you all, I've always talked about balance. You're not just here for the police department. You're also here for the public. And if you fail the public, you will fail the police department, because the police department cannot adequately do its job without community trust. Thank you so much.
Thank you, Counselor. Are there any other public comments? Hearing none, we'll move on to the item number 4.1, the Chief's report. So, Chief Burke, the floor is yours.
Thank you, Chair Depper. So I have a short two-page report because it will also have the 2025 traffic stop data report from Jeff Nicholson, who I anticipate will be joining us online. So to really cover this ground efficiently, the report is broken out in a few sections. The first is a staffing overview. As of today, we have 59 sworn officers, 51 are available for duty. The balance of those 8 officers that are unavailable for duty are either on injury leave, 1 is on military orders, 1 recruit is in the basic training class, and 2 remain under criminal investigation related to use of force cases by the Attorney General's office. In addition to our sworn staffing challenges, we still continue to experience vacancies in our professional roles, including emergency communication specialists, community service officers, and community support liaisons. We did change the recruiter role. Corporal Crystal Wren assumed our recruiter role in February 2026, and she is actively screening and processing candidates for all current vacancies. Next section is related to in-service training. We have Lieutenant Rich Weinish now overseeing the administrative office, which is responsible for our in-service training. We knew we needed an actual schedule so we could complete our state mandatory training each year in a more predictable and manageable way than had been done in the past. Thus far in the first quarter of 2026, sworn staff have successfully completed our Integrated Communication Assessment and Tactics training, which is informally known as ICAC. That's our model of de-escalation training, our state-mandated use of force training, CPR first aid certification, and our electronic controlled weapon, more formally or more commonly known as a TASER training. The department also fulfilled our annual training obligations to the Vermont Criminal Justice Council in March of this year. It's a very intricate process that was taken on by Shibe, our command assistant. In the light of the RIF last year, we did lose our training coordinator. However, Shibe, with the assistance of Shannon Trammell, really used technology to lean this process out and make it much more reliable, but it does necessitate a lot of document collection and then actually filing those documents with an annual affidavit with the Vermont Criminal Justice Council, which I execute, along with examples of our state mandated model policies. So that was successfully done, reviewed by the Criminal Justice Council, and we were found in compliance there. The third section of the report talks about a few of the major case outcomes. So the Chittenden County State's Attorney's Office has been working quite diligently in addressing the number of backlogged, especially murder cases from 2022 and 2023. Really with the help of the accountability docket, it freed up our local prosecutor, and I highlighted here 5 cases that have been resolved in early 2026 of murder and attempted murder. And what I'd like to say about this overall, it really exemplifies our staff and the work that they put into these cases and partnering with the state attorney to bring them to a successful closure. The closing paragraph here I think is important because these cases have a profound impact on the victims' families, the broader community, and the members of the department. While sentencing outcomes ultimately rest with the court, the successful resolution of these cases reflects the department's professionalism, diligence, and unwavering commitment to thorough and ethical police work. And then the last section of my written report pertains to the use of force review that the department undertook in the wake of March 11th. And the department has completed our review of the use of force complaints received from the public. We briefed the mayor on the afternoon of April 19th and provided her not only with the video, but all the supporting evidence and actually access to our investigator for any questions. The mayor then took that material, has gone through her own process, and I anticipate receiving her final recommendation shortly. So the department respectfully requests that the Police Commission consider holding a special meeting in early May. The meeting would provide an opportunity for BPD to brief the commission on the review findings as well as the mayor's recommendations in executive session. So with that, that's what I have. I'm hopeful that our data analyst, Jeff Nicholson, there he is, has joined us, and Shai will promote him to a panelist, and we've got the traffic stop data presentation ready for you.
Great. Thanks, Chief. Let me share screen here. And this. Great. Right. Yeah. Good evening, everyone. This is the third of 4 planned presentations looking at annual PD data from 2025. We have previously covered incident trends, offenses, arrests, as well as arrests by race. And tonight we're going to be taking a brief look at traffic stops, and particularly traffic stops by race. Sorry for the text-heavy slide here. I just wanted to be thorough because pulling this data, traffic data, is a lot messier than something like incidents or arrests. That's because Valcor, the PD's data system, doesn't really have one clean, single way to designate a traffic stop. While the PD is required to document each stop, regardless of the outcome of that stop, the information doesn't always make it onto the online portion. Recently, I found a handful of stops without any information in the tickets and warnings section of the incident. So in theory, I should be able to just pull every incident with the ticket or warning information, boom, we're good to go. But that's not quite how it works. And then there's an additional challenge where we're only looking at discretionary stops here as we examine potential officer bias. And again, there's not one particular checkbox that indicates whether something is a discretionary stop or not. And when I say discretionary stop, that's in contrast to you know, an externally generated stop, a response to a person driving erratically or a car crash or things like that. So I just did a brief detail of how I got this data set. This is every incident that's labeled traffic DUI or DLS, driving with a suspended license, as well as every incident with a traffic ticket or warning, and then going through and filtering out those externally generated stops, which was sort of a long process that involved various filters, incidents that had car crash reports, as well as just reading a lot of manual officer reports. And so because of high ticket volume in past years, I only did that check for this year, 2025. But I will say all of my methodology was cribbed very heavily from code written by past analysts. So I feel quite solid in my methodology. But just to kind of ground us all in what this data is looking at. So all that said, traffic stops. There were 957 of these discretionary traffic stops.
Can I interrupt you for 1 second and just say that I don't think the slides are following?
Oh, you're right, I'm looking at it. Thank you.
Yeah, no problem.
That's a problem. Let me stop and reshare. How about this one?
Great, thank you.
Great. Okay, so not that we need to reread that, but this was my text methodology slide. That was. So is there a delay? Are you still seeing the traffic stop slide, or are you seeing the methodology
I am
slide?
still seeing the traffic stops slide.
How about now?
There we go.
Great. Okay, thanks for pointing that out. Okay, so that was my methodology preamble. And here we see the traffic stops. There were 957 traffic stops in 2025. This total is more than double the total from 2022, but as we see, it's still well below what we have seen, 10 plus years ago, where there would be multiple thousand traffic stops in a given year. One more long text slide. This is talking about race, since the remaining slides will be looking at the race of the driver for these stops. When officers are filling out a ticket or a warning, there's a field for perceived race. So this is where the officer fills out their perception of the ticketed person's race rather than what it might say on their driver's license or something like that. And we use this data field for analysis for traffic stops because officer bias would depend on their perception of that person's race. So that is the most accurate data point we can use in examining this. And also for estimating the racial share of all drivers in Burlington, we use crash data that's compiled by the Vermont Agency of Transportation. And what that is a big data set of all the crash reports filled out from Burlington by BPD, the state police, and UVM police. And that is also perceived race. So yeah, just a note on that's what we're looking at as we look at race for the remainder of the slides. This is the perceived race by the officer doing the stop. As I mentioned previously, I discovered a handful, 30 or so stops that currently don't have the perceived race field filled in. The chiefs have been notified, and we're working with the records department and the officers who wrote those tickets to get that updated. And so when I submit final data, that will hopefully be all amended by then. Okay, no more text slides. So this is the race of the driver of all traffic stops dating back to 2012. You'll notice that most stops before 2017 have missing data. I believe that's because I still think the information was written on paper tickets, but perhaps they didn't get migrated into the Valcor database, so it's all missing on the back end beyond being attached as a copy of the written ticket. So we're leaving that blank. So we're going to zoom in to just 2017 and beyond, where we have data in Valcor. So in 2025, 77% of traffic stops were of white drivers and 16% of them were of black drivers. The remainder being divided between Asian, Hispanic, and Native American drivers. 77% is the lowest percentage of white drivers on record in the data set, and 16% is the highest percentage of black drivers on record in the data set. So here is where we're going to compare, like I mentioned previously, the PD traffic stops to the percentage of car crashes in Burlington based on the race of the driver. So the dotted line is going to represent the percentage of vehicle crashes reported to the state, and the solid line is the percentage of BPD's traffic stops for that race. So on the left side of the screen is a graph for white drivers. We see in 2025, 76% of crashes involved a white driver and 77% of traffic stops were of a white driver. And over on the right side, we look at races other than white, particularly we're looking at the green line there that represents black drivers, where 14% of crashes involved a black driver and 16% of traffic stops were of a black driver. We also can see that with the exception of 2021 there in the middle of the graph, percentage of traffic stops for black drivers have consistently been at least a few percentage points higher than crashes involving black drivers. Next, we're looking at a few things. First, we can take a look at the second row of this table here, and we're going to look at the median duration of the traffic stop. First, I'll say that the way I calculate this median duration is by using what's called the on-scene time and the cleared time in Valcor. I would like to say that that information is manual, as in the officer enters. I guess I don't know the specific, maybe Chief Burke can be more specific about it, but the officer enters the time when they start the call and the time when they clear the call. It's not, auto-dictated by GPS or anything like that. So there is some room there for user error or some unclean data, but it is the best metric we have to measure length of an officer engagement. And so I calculated the median duration of stop as opposed to, the average or something like that to try and control for any erroneously long or short stops. So we see that the stops of Asian drivers were the shortest, were 6.5 minutes, followed by white drivers, 6 minutes and 47 seconds. The median stop of a black driver was about 45 seconds longer than the median stop of a white driver. And the median stop of a Hispanic driver was over 2 minutes longer than the median stop of a white driver. We are dealing with 28 stops there, but that is still a 2 minute longer median. The remaining rows in the table are looking at the state of the driver's license plate by race. 85% of stops for white drivers had Vermont plates compared to 90% of black drivers, 89% of Asian drivers, and 83% of Hispanic drivers. And you'll notice in that bottom row, we see like 90 or so stops where we're still working on potentially filling in some missing information as it pertains to license plates of stopped vehicles. This next slide dives back into the median stop length by race, but this time we're dating back to 2021. In all years, the median stop of black and Hispanic drivers has been longer than the median stop of white drivers. You'll notice I excluded Hispanic stops for the first 3 years of our chart here because the M value is less than 5 stops, whereas in 2024, there were 13, and in 2025, there were 28 stops of Hispanic drivers. Next, this is the reason for the traffic stop. All the values you see in the legend over on the right there are options that the officer selects as part of their ticket or warning. The vast majority of stops, as we see, are either for moving violations, which is speeding or a stop sign, or the vehicle equipment, which is expired registrations, no lights, etc. Some of those options, like externally generated or investigatory, might typically preclude them from this data set since they might mean that it's not a discretionary stop, but as I was reviewing the data, I found them to actually be discretionary stops, and so I left them in as is. So when we look at the data, we see that 74% of stops for black drivers were for moving violations, compared to 72% of white drivers, and 25% of black drivers stops were for equipment, compared to 24% of white drivers. Smaller sample size for the two races on the right there, but 87% of stops of Asian drivers were for moving violations, and 54% of Hispanic drivers were for moving violations. So this is, the chart on the left is the same chart we just saw, but the chart on the right introduces the previous 4-year average for the same data points. And here we see a more pronounced disparity where in 2021 to 2024, 80% of white stops were for moving violations, compared to 71% of black stops, and 17% of white stops were for vehicle equipment, compared to 25% of black stops. One more data point here. This is what we call traffic stop outcome. Again, this is a field that the officers fill in as part of the ticket and warning process, and it describes what happens as a result of the traffic stop. And again, you'll see the majority here are either a warning or a ticket. There are a couple other options that can be chosen. Arrest for violation, which I believe is if you were arrested for the reason you got pulled over. There's no action taken. And there is arrest warrant, which I believe is when the person pulled over is learned to have had a warrant out for their arrest for an unrelated crime, okay, as compared to their traffic stop. Chief Burke, feel free to chime in if I got that wrong, but I believe that's how that goes. And where are we here? Yeah, so white drivers got a warning 77% of the time, and black drivers got a warning 74% of the time. For Asian drivers, 79%, and Hispanic drivers, 68% of the time. And again, I wanted to bring in the previous 4-year average, and again, a slightly more pronounced disparity when we look at the historical data. Over the previous 4 years, 80% of white drivers received a warning, compared to 75% of black drivers. And my last slide here is we wanted to look at all the searches that occurred during discretionary stops in 2025, and there was just one on file. This was a February 2025 stop of a white driver, stopped for failing to use their turn signal and having an expired registration. The driver was known to the officers as being involved in drug use and distribution. The operator admitted to having crack on his person prior to consenting to a search of his person and vehicle. Officers located a crack pipe and 2 digital scales. No arrest was made. So that is our one traffic stop search for the year 2025. And that's all I got for traffic tonight. As a reminder, once I get through these presentations, I'll be assembling sort of an appendix that contains all the data tables that fed all the charts for these presentations that will get sent over. My last presentation will be a look at use of force data for 2025. And yeah, I welcome any questions either tonight or in the future. Feel free to reach out to me with any questions or data topics you might want to talk about.
Thank you very much, Mr. Nicholson. Commissioners, is there any discussion or questions for Mr. Nicholson? I can't see anyone online right now, so. Okay. Hearing none, thank you very much for your presentation, Mr. Nicholson. I sure appreciate your time. Does anybody have any questions for the chief about his presentation? No? Hearing none. Thank you very much, Chief. I appreciate the report and Mr. Nicholson's time as well.
Thank you.
And we will move on to commission business. As we articulated earlier, fair and impartial policing policy regarding March 11th ICE operation community organizations discussion has been moved up to 5.1, so we will start there. I believe actually that, oh, go ahead.
There is an item 2.
Which item 2? I'm sorry.
Item number two is bylaws discussion continuation.
Yes, ma'am. I understood that fair and impartial policing regarding March 11th ICE operation community organizations discussion was moved to amend the agenda to move it up to 5.1. And that motion carried, which would, in my estimation, move committee reports to all committees down to 5.2, bylaws discussion down to 5.3, and then Bodycam Release discussion and open letter discussion would be 5.4 and 5.5.
That was my intent. I don't know if that was clear in my,
That was my understanding.
That was not clear to me, but okay.
Okay. Then we will continue with the fair and impartial policing policy regarding March 11th ICE operation community organizations discussion. I understand that one or more people are here to present on that, in that regard. Okay. If the first person, I believe I simply know Mr. Lambeck. I know you work with Migrant Justice. If you would like to go first, that would be fine.
can I give some brief background
Yes, please.
of, and I think we also have some people from Vermont Asylum Assistance Project here as well.
Okay,
Thank you
excellent.
very much for coming. I just wanted to give some background because I'm the one that proposed this, and thanks everybody for putting that on the agenda. So Vermont statewide fair and impartial policing policy is an evolving document that's been integral to our modern policing initiatives. The long debated updates that were incorporated in 2024 included some more robust descriptions of bias based on immigration status and outlined some prohibitions on participating in civil immigration activities. We saw these issues come to a head in our community on March 11th when hundreds of neighbors showed up to protect each other in an incredibly brave show of solidarity. I think it's fair to describe what happened that day using the same words that many officers did on the scene. It was a shit show. The events of that day have eroded trust in our local law enforcement agencies, including BPD. We've heard from their respective police agencies to give their opinions on this matter, so I wanted to welcome other agencies to give their opinions of any lessons learned from the outcome of this operation in an attempt to have a better or different outcome next time. So if you could come up and introduce yourselves and go right ahead. Thank you.
Thank you very much, Commissioners. Appreciate the opportunity to address the Burlington Police Commission. My name is Will Lambeck. I'm speaking this evening representing the organization Migrant Justice, a nonprofit Vermont-based human rights organization founded and led by immigrant farm workers in the state. Is there a guideline for how long I should keep my remarks to?
Well, all our commission business is set for 90 minutes, so I'd ask that you not take that much time. Certainly, I would suggest between 5 and 10 minutes, but we don't have a hard and fast rule for this type of presentation.
Understood. Thanks very much, and I think I can keep it within 90.
Okay, thank you.
As you heard, we were asked to come in and provide a little bit of background about the history of the fair and impartial policing policies in Vermont and Migrant Justice's perspective and participation in the creation and updates of those policies. And part of the context around this has been the suggestion in the wake of March 11th that fair and impartial policing policies weren't created with situations like what unfolded on Dorset Street in mind. And I hope through my remarks I can push back on that notion and really leave the Commission with the impression that the policy was created precisely with the events of March 11th in mind. So I won't go back to the very beginning, but what we're talking here, the statutory construction around fair and impartial policing is in 20 VSA 2366 in Vermont statute. That statute has been updated a number of times over the years. In 2012, for the first time, the legislature mandated that all agencies adopt what at that point were called bias-free policing policies, and that language later got changed to fair and impartial policing policies. In 2014, in Act 193, the legislature updated the statute and amended it to say that all agencies need to adopt a policy that conforms to a unitary statewide model policy and set in place a process for creating that model policy, naming among other stakeholders Migrant Justice as a stakeholder to be consulted in the creation of that unitary model policy. So that set off about 16 months of concerted conversation conversation, negotiation, and quite a bit of healthy and productive debate within the Criminal Justice Council and with community stakeholders. So the leads on that from law enforcement were Commissioner Morrison, although not commissioner at the time, Chief Brickell, and Major Ingrid Jonas of Vermont State Police. And on the community side, Jay Diaz from the ACLU, Mark Hughes from Justice for All, and a number of representatives of migrant justice were involved. And really, from the beginning, it was understood by all parties that questions of immigration were integral to the creation of fair and impartial policing policies in the state, and in particular, to have a robust policy that prevents discrimination based on race, national origin, and other protected classes. We need to have a policy that properly restricts law enforcement's role to public safety, and in the sort of phrase that we've used throughout the years, ensuring that Vermont police are not in the business of deportations. And that's actually been a pretty consensus opinion among all stakeholders looking at the policy over the years, and the debates have been in the details. So the first model policy that was adopted by the Criminal Justice Council, what was then the Criminal Justice Training Council in 2016, included a couple provisions that I want to highlight. I can, of course, share the policy with the Commission later. Section 5C says, agency members shall not facilitate the detention of undocumented individuals or individuals suspected of being undocumented by federal immigration authorities for suspected civil immigration violations. And Section 7D, subsection C, says, agency members are not permitted to accept requests by ICE or other agencies to support or assist in operations that are primarily for immigration enforcement. Now, this was language that in both instances was proposed by Migrant Justice and drafted along with the ACLU. And if that language sounds familiar, it's because those are provisions that exist in the current model policy and in Burlington Police Department's policy, more or less in the same language about a decade later. And so those have been part of the policy throughout. But as was mentioned, there have been additional iterations, and the policy has been at times weakened and watered down. There were additional carve-outs and loopholes put into place in 2017 after threats from the first Trump administration. Many of those loopholes were then tightened or deleted in their entirety, and new provisions were put in that strengthened the policy's protections in 2024, right before the beginning of the second Trump administration. And so the 2024 model policy is now what controls in the state now, and what Burlington's current policy is based on. So those provisions, don't accept requests from ICE or Border Patrol, don't facilitate the detention of people for immigration violations, remain in the policy. And then one of the additional pieces put in 2025 looked specifically at this sort of gray area that had existed around criminal immigration enforcement, and it really took a hard look at that, and also said this isn't within the purview of public safety and the mandate of law enforcement in Vermont, saying it is not a priority, and accordingly agency members should not make warrantless arrests, detain individuals, facilitate the detention of individuals, or otherwise expend resources investigating or enforcing unlawful entry or unlawful re-entry cases. And it goes on, and we can talk about the second part of that, but I want to highlight here unlawful re-entry cases because that is the criminal offense that began the immigration enforcement action, or the suspected criminal offense that began the immigration enforcement action in South Burlington on March 11th. So the policy has always had these prohibitions on accepting requests and facilitating the detention of people for civil immigration enforcement, and then in 2024 added in and strengthened this additional provision to say criminal immigration enforcement like unlawful reentry can't be used as a loophole to get around it, and that's also discouraged. So what we've seen is, and going back to the provision that I was just reading from the current model policy is that in narratives following March 11th, there's been this real emphasis on the public safety imperative of law enforcement participation in the enforcement activities. Continuing to read 5B, this again is the provision about the criminal enforcement, unlawful reentry is not a priority. It goes on to read, unless such actions are, one, necessary to ensure public safety or officer safety, and then it defines it, imminent risk of physical injury to subject, officer, or third party, or two, integral to the investigation of criminal offenses unrelated to immigration law. And I want to focus on the first carve-out there, because that was something that was extensively debated, and I see Aaron Jacobson is here. Maybe you can talk about that as well. And really, a lot of heads came together to try to strike a balance on this, and adding in that very specific definition of imminent risk of physical injury was important, because what we had seen in previous iterations of the policy, particularly the 2017 model, is that in other sections of the policy, references to public safety were being used by agents as a pretext to engage in immigration enforcement. So he said we need to tighten that up and really define, if you're going to say that public safety or officer safety compels us to assist in immigration enforcement, what does that mean, and what's the standard for making that determination? And so when you look at the history of the policy, when you look at the current provisions in the policy, we believe very strongly that it's impossible to come to any conclusion about law enforcement's participation in the ICE raid of 3/11 other than that this was in violation of Vermont's fair and impartial policing policy. It's in violation of the intent, it's in violation of the spirit of the policy, and it's in violation of the letter of the policy. And we can say that with a good deal of confidence, again, because we drafted the provisions more than 10 years ago that were violated by multiple agencies on March 11th in South Burlington. Looking again on this question of public safety, first, it's defined narrowly, and we don't believe the standard was met on 3/11 to say that when law enforcement arrived on the scene, they were there because of imminent threat of bodily harm. But even beyond that, what we see in the various legislative testimonies, city council meetings in Burlington and South Burlington, and press conferences and press releases, is that when further questions on the matter, law enforcement officials will readily admit that not only were they there for public safety, but they were there to allow ICE to do their job, meaning allowing ICE to unconstitutionally detain 3 individuals living in that house on Dorset Street. So I'll read just a couple of those quotes from various officials from the Vermont State Police press release on March 11th. The state police, including members of the critical action team, ensured federal agents were able to pass through the crowd of protesters to reach the residence and carry out the lawful order of the court. At the Governor Scott's press conference on March 18th, Commissioner Morrison said, police used a highly trained team to create a very narrow corridor to allow the ICE agents to do their job. At the legislative hearing on March 19th, South Burlington Police Chief Bro said, it was assumed that ICE had every legal justification to detain the individuals, meaning Johanna, Camila, and Christian. And Burlington Police Chief Burke said during the same legislative hearing, the actions of Vermont law enforcement in South Burlington aided in the execution of a criminal warrant. And again, we're talking about a criminal warrant for unlawful reentry, which is specifically addressed by the policy, and which says it is not a priority and agents should not facilitate the detention of people for unlawful reentry. He said, we aided in the execution of that criminal warrant. And once the agents were in there, meaning inside the house, they still have their lawful authority to do what they need to do. And in that case, what they needed to do was violently detain 3 individuals who were later released by federal judges who said that those detentions were unconstitutional violations of the 4th and 5th Amendment. And finally, the final quote I'll read is that from Commissioner Morrison at the legislative hearing on March 19th, saying, "That was the plan all along, to provide for separation so that everybody could do their job. Protesters could do their job, agents could do their job." So by the words of law enforcement officials themselves, there should be no doubt that the intention of police on March 11th was to allow ICE to do their job. In other words, to aid them to facilitate the detention of individuals for immigration violations. And so what does that mean going forward? We think that compliance with the fair and impartial policing policy requires, on behalf of the City of Burlington, an affirmation of the content and application of the FIP in situations similar to this one. And what this means in practice is that if in the future Burlington Police Department receives a request for mutual aid, it is incumbent on the department to verify if the provision of mutual aid would put them in violation of the fair and impartial policing policy. If the request for support came from ICE, or if the action is in furtherance of immigration enforcement, the department must decline the request. To do otherwise would be to violate the fair and impartial policing policy. Now, we want to be clear. We don't believe that the policy prohibits Burlington Police Department from being present at immigration enforcement actions, but it does place certain restrictions on that presence. Presence cannot be precipitated by a request from federal immigration agents, as was the case on March 11th. Presence must strictly conform to a public safety role, not acting, as BPD did and has been admitted repeatedly by police officers, to allow ICE to do their job. Public safety objective must include, as mandated by the use of force policy in the state and as adopted by BPD, that officers, quote, intervene whenever they witness another officer using excessive force. So in other words, in sum, if Burlington Police Department officers are to be present during immigration enforcement actions under a public safety justification, then they must actually keep the public safe. This can never be used as a pretext for supporting ICE, as was the case on March 11th. And then going back to the criminal investigation piece, a declaration of criminal investigation by federal immigration authorities, including the presence of a criminal warrant, does not give BPD carte blanche to support the enforcement action, as has been suggested. The FIP continues to place severe restrictions on criminal immigration enforcement actions. And as we saw on March 11th, what began as a criminal enforcement action for unlawful reentry ended as a civil enforcement action. None of the 3 individuals detained were accused of any crimes. ICE, quite simply, cannot be trusted to limit their actions to their stated target. And their so-called collateral arrests are always a possibility. Thus, any support provided for criminal immigration enforcement could result in support for civil immigration enforcement, as happened on March 11th. So as a matter of practice, BPD must also decline requests for support on ICE investigations of unlawful entry and reentry as determined by the policy. So these practices, already mandated by the policy, should be affirmed by city leadership. We believe these should be the standards that the police commission should hold the police department to, and officers must be trained to these standards. Thank you. Open to any questions.
Thank you. Any questions from the commissioners? I have one, Mr. Lambeck. It's something I've been curious about. Were you at the March 11th protests and ICE operation in South Burlington?
Thanks for the question, Commissioner. I was not, no.
You were not?
No.
Okay. Did Migrant Justice have any individuals there that, you know, as an organization to observe?
Yes, there were multiple people representing the organization there.
Okay. And so my question, you may not know this, but I was curious about it. Do you know, were there any legal observers there, or, you know, any attorneys brought in to, you know, just kind of observe the protest, or, you know, comment on, I mean, obviously I think we've had testimony here already that there were some period of hours before the warrant showed up, and I was always curious as to why no one called a lawyer.
Yeah, there were attorneys present throughout the day, and interventions from Vermont Legal Aid attorney. A Vermont Legal Aid attorney was crucial to extricating the child from the house, and she was able to interface with immigration, and she would tell you not very successfully in terms of actually being able to engage in a dialogue with
Sure.
ICE agents there. But yeah, there were attorneys present, and there were lay legal observers present as well throughout the day.
Okay, thank you. And I'm sorry, you had a comment?
She needs to come up to the microphone.
Okay, thank you very much. Could you come up to the microphone real quick and just identify yourself for the record, please?
Hi, yeah. My name is Rachel, they, them. I'm also a member of the Migrant Justice Team.
Okay,
Rachel Elliott.
okay, great. Thank you very much. I appreciate it.
Yeah.
Does anybody else have any questions for Mr. Lambeck? Or, I'm sorry, I didn't catch your last name.
Elliott.
Elliott. Ms. Elliott? No? Hearing none? Thank you very much. I appreciate your time.
Thank you. Jill, did you want to come up? Thank you.
Thank you. Thank you, Jackson and Aaron. Hi, everyone. For the record, I'm Jill Martin Diaz. My pronouns are they, them. I'm the executive director of Vermont Asylum Assistance Project, and I'm an immigration defense attorney. I've been practicing for about 10 years, and I'm joined here by a longtime practitioner colleague of mine.
Hello, my name is Erin Jacobson, and I am here speaking from my new role at Vermont Asylum Assistance Project as also an immigration defense attorney. In many ways, I'm returning to an old role. I've been practicing immigration law for a long time. Some of you might know me more recently as the mayor of Burlington's chief of staff. Prior to that, I was at the Attorney General's office, which is why Will Lambeck looked to me when he was talking about the most recent updates to the fair and impartial policing policy, because I did work on that on behalf of the Attorney General at that time. But I want to emphasize, I'm here tonight to speak in my role as an immigration attorney at FAP.
So I so appreciate the timing of us being able to speak with you all now, because the question of were there any lawyers called is very apropos. Where are the lawyers you call when ICE is looking for you, right? So we're the foremost provider of free, no-cost immigration defense legal services in the state of Vermont. We work closely with a coalition of 4 other organizations statewide, and together across the 5 organizations, there's about 15 free immigration lawyers now serving the state. When the enforcement climate changed at the start of 2025, there were just 2 of us who were licensed to defense attorneys here in the state. So it's been a time of incredible change. We've been able to do a lot of great work to uphold individuals' constitutional and civil rights in the face of what appears to be a pattern and practice of deliberate violations of people's due process rights, their speech rights, their rights to privacy, freedom from surveillance, their right to be free from cruel and unusual punishment at the hands of ICE officers. And I want to underscore that I come to you to offer our perspective on what we see are the impacts of March 11th, the risks of what we could see maybe worsening if we continue down this adversarial trajectory, and really to uplift the work of mutual aid providers, rapid responders, accompaniment providers, legal observers, and witnesses like those coordinated by the Migrant Justice Rapid Response Network. The way that we do a lot with a little as an emerging immigration legal service practice is we stay glued to our laptops preparing to file motions in federal court. Unfortunately, we find that being in the field and trying to confront ICE agents who are acting in bad faith and who are armed with the letter of the law has not been an effective strategy to help uphold people's rights and keep them safe. Instead, what we have learned in Vermont and nationally is that we need to waste absolutely no time in going directly to the federal district court, filing for judicial oversight of what ICE is doing. And that's the kind of litigation you hear about, habeas corpus litigation. It's a common law doctrine called produce the body. It's a core constitutional right, many scholars argue the most fundamental. It's this idea that even in the executive branch, even armed federal law enforcement cannot just disappear bodies. You need to be able to account for what happens to people's bodies. And beginning in 2025, habeas corpus review became the primary mechanism through which former administrative practitioners like us are able to make sure that not only ICE has accountability for how they are violating individuals' rights, but that we are interrupting the harm from continuing on. So our work picks up after the arrests happen. So in this case, there were 3 arrests made of non-citizens, Camila, Joanna, and Christian, and they were not the individuals that ICE was looking for. This is a very common fact pattern. We get anywhere from 1 to 5 new calls for help of this description every week nowadays. Opportunistic arrests. If a person is arguably present, maybe without status or having their status lapsed, ICE might arrest them and put them into civil immigration removal proceedings. That's when we get involved. We very much look to our community partners like Migrant Justice, the legal observers that you describe who are on the scene to collect witness statements, to understand, piece together what was happening in the moment, not just because we want to understand what the person's immigration options might be, but because in order to stabilize their detention and to prevent ICE from relocating them out of state in the dark of night to far-flung places where their counsel and their family can't find them, like Louisiana and Texas, and Alligator, Alcatraz, we need to get a case going in federal district court immediately. Its time is of the essence. As lawyers, we are officers of the court. We're required to do diligence, to trust but verify the information that is shared with us by people requesting our help. We we have a methodology for how we corroborate facts. We assess how a fact finder might look at the facts that we're presenting. The standard of practice in federal district court could not be higher. So for us immigration lawyers used to the Wild West of administrative immigration court, it's been a very rigorous couple of years for us. Suffice to say that when we received the calls for help for Camila, Joanna, and Christian, and together with the 4 other providers, ensure that they had access to immigration counsel and habeas counsel, we very, very quickly corroborated that there were indeed constitutional and civil rights violations at the hands of ICE for these 3 individuals. And that's why we did not delay filing for habeas corpus review in the District of Vermont. Already, 3 different written decisions by the District of Vermont have made findings that ICE acted illegally that day, and that the remedy for these 3 individuals was immediate release from detention. That's how those individuals were able to walk free. The reality is that their immigration defense journeys are just beginning. Now they are just beginning this arduous process of rehashing the most traumatic details of their lives to seek humanitarian legal protections that have been enshrined in our law since World War II, that are now under attack by the administration, well-settled law. And they have the disadvantage of having to talk about their experiences now with the trauma of March 11th, of their detentions, getting in the way of their ability to work on their cases. I share that with you because I hope that as we make sense of March 11th, that we join our community members in centering the needs and impacts of those most harmed on March 11th, and that was Camila, Joanna, and Christian. And not just them, but the other people in the household who witnessed how ICE treated them, the children that were struggled to be evacuated from the home, the other immigrant community members who had to send their kids to school the next day or drive on the highway the next day for fear of being stopped at an ICE stop. The terror that we have been promised in the media is what everyone saw with their eyes on March 11th right here in our community. And if there was distrust in public services, in public health, in emergency support, even in humanitarian immigration law that's been settled for decades, imagine how much more difficult it is for us after March 11th to convince the community, no, it is safe to go to the emergency room if you need it. You can still send your kid to school. You can still call 911 if you feel you're in danger and you need protection. That's always been why that perspective is what's driven immigration lawyers like me to be very supportive of creative solutions like the fair and impartial policing policy, to really build trust with the individuals that the federal system is so hell-bent on scaring into the shadows. And what we have seen since March 11th is not only ICE continuing to arrest people in violent and illegal ways. We have had many more decisions from the Vermont District Court ordering ICE's activity illegal, requiring ICE to let people free. This continues to be the case. And meanwhile, the fear among the community has never been higher. And we're worried about our vulnerable community members not being able to restore faith in the emergency systems and services that are designed to protect everyone. If we as a community cannot find a way to take accountability, to repair, and to heal from what happened on March 11th, and to get back to supporting our non-citizen community members in their arduous fight for defense against unjust removal. I want to pass the microphone to Erin, who is representing many individuals right now in these habeas corpus cases, and she can speak to the impact on clients of March 11th, and particularly the very important essential role that rapid responders play in making our legal work possible.
Thank you, Jill, and I am being mindful of time. But I think one way to speak about the impact of March 11th and the importance of mutual aid and what happens when there is fear in communities that might negatively impact the provision of mutual aid is actually to tell you about another case that I just wrapped up actually last night. My client was released last night. So this is very fresh, but it's I think, an illustrative story because it demonstrates what happens when there is no good mutual aid. It demonstrates what happens when people are afraid to stand up and help because they might be afraid to put their names on a piece of paper. So the client who I did manage to help get released just last night was yet another unconstitutionally arrested non-citizen with no criminal record. So whatever ICE is saying about focusing on people with criminal backgrounds is practically almost completely untrue. The vast majority of these people have no criminal backgrounds, and the vast majority of our clients have no criminal backgrounds. My client was arrested because he accidentally went to the Canadian border after his GPS failed. He was driving his partner home from a medical appointment in Burlington, Vermont to Chazy, New York. That's all he was doing. And for that, he was arrested and then unconstitutionally, without due process, detained for almost an entire month. Unlike the people who were arrested on March 11th in South Burlington, My client lives in a very rural place in upstate New York that does not have a lot of mutual aid or people who are willing to stand up and help. Nobody wanted to write letters of support. My client's partner was the one person who could help, and she has significant health issues and very few resources, and without her partner was raising a 3-year-old on her own while working more than full-time at a poultry farm. She spent most of her waking hours, plus hours she should have been sleeping, trying to identify people who could write a letter, people who could maybe help her figure out how to get bank records, tax records. What we have to do to prove to the government who has unlawfully, unconstitutionally kidnapped and detained people, what we have to prove about why they should be let out is a very onerous process that requires not just a lot of legal work, but a lot of evidence. And we cannot, on our own, easily obtain that evidence, nor can the family members who are left behind, and certainly not the people who are detained. So our work is cut out for us when we do not have the assistance of mutual aid, when we do not have community members who can write letters of support, help figure out how to get records, medical records, bank records, tax records, letters from clergy, letters from schools, letters from employers. And what happens when you cannot obtain enough evidence to prove to the government why someone has community ties and is not a danger to the community is they end up with very high bonds, if they're even going to be released at all. My victory for my individual who was let out last night didn't feel like a victory at all because he was issued a $10,000 bond. This is a family who can barely pay their bills. This is a family who does not have $10,000. Because of that, he also spent an additional week in detention. That's what happens when we don't have community support or when people in our communities are afraid to step up and help. And that is a risk that we stand when we have incidents like March 11th, when everyone might be well-meaning, but sometimes then we end up in a situation where the next question becomes not just, was there a policy violation? I hope the beginning and end of this inquiry about what happened on March 11th isn't just, was the use of force policy violated or was the fair and impartial policing policy violated? I hope that's not the beginning and end of the inquiry, because the inquiry really should be, how do we reestablish trust that I know for a fact, because I've worked with him, Chief Burke cares very deeply about the trust of this community. And so I trust that this community is both willing and able to think creatively and seriously about how we move forward. And I think that Will Lambeck had some good suggestions about what we do with the policy we have. Maybe we take a look at it and think, do all officers understand it? Do we need more training? Maybe we think about, how does this policy apply to a situation like March 11th? Because that situation is probably going to happen again. ICE is not going away anytime soon. And when they see communities like ours divided against ourselves, they win. And so I hope we can move forward, not just in thinking about fair and impartial policing policies, but what we can do to reestablish the trust that we all desperately need to have in this community for each other. That was the whole point of the fair and impartial policing policy, was to make sure that everybody knows and understands that police are here for public safety, no matter who you are, the color of your skin, where you were born, the language you speak. And so I hope that that is something that can be communicated from what happened on March 11th and how we move forward. Thanks.
Thank you. Do any of the commissioners have any questions? No? I've got a couple of questions. I'm not plugged into this area of law like y'all are. So my first question is, there's been like public reporting around the country about, some attorneys general or DAs, depending on your state, looking at ICE activity after the fact and charging individual ICE officers with violations of state law. Is there any movement in that regard here in Vermont? Can you all speak to that a little bit? Is that even a thing?
it's not a thing yet, it hasn't happened yet, I think it absolutely could and should be a thing. If an ICE officer violates the law, violates criminal law, and there's probable cause to charge it, then certainly I think a prosecutor should charge it. One thing that we talk about a lot is how there's one agency who is not going to be examining how they can do better. Did they violate policies? How can we train our officers better? They're not going to hold themselves to high standards like our local and state law enforcement have to and want to, and that's ICE. And so if they're not going to hold themselves accountable, then they need to be held to account. And one way you're held to account is through a prosecution of our criminal laws.
Okay.
What I would add is there's been a few innovators who are starting to bring these cases. It implicates this question of like federal preemption, right? So there's sensitivity and different risk tolerance. I don't know, I can't speak personally to whether Attorney General Clark or Attorney Sarah George have an appetite to pursue those kinds of remedies. Something I think a lot about, though, is like, what are our goals? What are our options to get us toward our goals? And is that necessarily the best option? I would be remiss if I didn't point out that if we as a state have legal resources to put toward this issue, I would probably sooner go to the federal judiciary and ask them to uphold our U.S. Constitution and stop ICE and release an immigrant who is being unlawfully detained, sooner than I would say, let's prioritize resources to try and criminally prosecute a single ICE agent as a deterrent, or does that get a remedy for the individual non-citizen? I don't know. That's just my take. I think if we have resources to offer here as a state, I think it should be, how can we be thinking about serving the needs of the non-citizen communities, of the communities that they're a part of, whose rights are also implicated and at stake. We at VAP are really interested and available to provide technical expertise to Chief Burke, to the city, to the state, thinking about what are the options, what are our goals, and how are we going to get there. But to Erin's point, I do think that we are united here, all of the stakeholders in this room, that the spirit of this policy was about community trust. It seems like we have agreement that trust is eroded, and I hope that we have agreement that we should be working together to fix that.
Okay, thank you. And my next question, is there an organized legal observer program in the state, either through the bar or the law school?
Not through the bar or the law school. There is a law school chapter of the National Lawyers Guild Legal Observer, so there's a loose network. Basically, it's an informal network. A supervising attorney can lend their license as an officer of the court to supervise observers, give them instruction on how to take contemporaneous notes using their 5 senses, and then how to transmit the note timely to a lawyer in the event that those notes would be helpful in a legal action. And that has absolutely been a resource that we've tapped into. There isn't like one formal agency, there's community organizing groups. Sure. But yes, there are legal observers, there are attorneys supervising observation work. I've done training in legal observation here in the state, and we've absolutely relied on those reports in our legal work.
Okay, great, thank you. Does anybody else have any comments or questions? No?
Oh, I just really appreciate all 4 of you coming and sharing your insight. It's really, really helpful, and thanks, Julia, for organizing.
Anybody else? No? All right, well, thank you all very much. I sure appreciate your time.
Thank you very much.
I just wanted to add one quick thing.
Sure, please, have a seat.
When you review the oath that our officers take, that oath includes upholding the Constitution. Thank you.
Sure. Thank you, Counselor. All right. Is anybody else here to speak on that particular matter? Okay, hearing none. Do the commissioners have any more commentary or questions among ourselves? No? No? Okay, thank you very much. Then we will move on to what is now 5.2, committee reports from all committees. The Complaints Committee would be first.
I don't have an update at this time. I was hoping we would discuss that in executive session today, which would not happen. So I would just say that I hope we can schedule that special meeting in early May as Chief Burke requested.
Sure, thank you very much. I would, it's not a formal motion, but I agree. I think we should get that on the books as soon as we can and move that forward. I believe we now have, I did want to mention this, I believe, and I wanted to make sure that the complaints are now being forwarded to the entire commission. I asked that that modification be made to the email service. Is everybody getting them?
Yes.
Yeah, okay, great. The next one would be the Animal Control Committee. Commissioner Cox, you had a comment. I see your hand up.
Yeah, I'm just, sorry. I would just prefer that it not be sent to everybody, which is sometimes a long time goes by. And as long as Julia or somebody's putting them into the folders, I don't need to get the initial complaints.
Okay, I appreciate that.
They're not at issue until the police department has done their investigation, come up with a disposition, and then that's the first time it really becomes super relevant to us.
Okay, I appreciate that. Would you, you can certainly request to be taken off the forward. I can't forward any things individually anymore on the regular just because of the data constraints on the city's email client now, so it's being forwarded out directly from the system. Would you like to be taken off of that forward?
I just don't understand the point of why you're doing it that way. I mean, Julia's putting them into folders, so we have access to them whenever we want to go and peruse them or anything like that, but otherwise it's just sort of clogging up my inbox.
Sure, well, I understand that. I've had several commissioners ask for that information and that it be forwarded to them, so this is the most efficient way to do that. But if you would prefer to be taken off that forward chain, I'm happy to ask the police to do that.
Yes, please.
Okay, thank you. And Chief, you're sitting right here, so I'm just going to ask if you could just make a note of that. I appreciate it.
Happily.
Thank you. Now, the Animal Control Committee. Commissioner Finneran, I believe you were chairing that committee.
Thank you. We had, on the 1st of April, we had a hearing for the dog bite case around a dog named Raven and another dog named Louise who died as a result of the dog bite incident. We were joined by the complainant and her partner, the two owners of the dog that passed away, and 2 experts, a vet and an animal behavioral expert. It was very helpful to have their opinions and knowledge as we were deliberating what to do with this case. We eventually sent out an order to the complainant and the owners of the dog that bit the other dog, and essentially we came to the conclusion that we would like to meet with everybody again because we were not able to hear from the owner of the dog who bit the other dog. It was not clear at the time if that person had received notice of the hearing at all, and then in follow-up we have discovered that she likely did not and did not attend the meeting out of any disrespect for the process. So we are going to give that owner another chance to come before the committee and in front of the complainant and see what we can get done there. And we will aim to schedule that meeting for a Wednesday, hopefully very soon.
Okay, great. Thank you very much. I appreciate that, Commissioner. The only other thing I had on this issue was we've been waiting for this for a while. We did get our website updated with the previously voted on language to modify the drop page. So that has finally happened, and I just wanted to update y'all on that. Let's see. All right. Anything else on 5.2 committee reports? Nope, hearing none. We will move on to what is now 5.3, the bylaws discussion, a continuation, and I will point out a couple of things. We were having some difficulty. Most of this was done in Word initially. We had markups. Those then apparently got transferred to PDF. Some of the red lines, so to speak, did not come through on the PDFs. Our last, if anyone's watching this online or has their computers, in our last meeting, we did have these markups in red line, so you can go to that last meeting on the Civic Plus or whatever it is, to find those red lines. I know all the commissioners have received the red lines. I believe Commissioner Paul has a unified red line document that contains the red line commentary of both herself and Commissioner Genorio, and includes notations as to what was already previously adopted. I believe that would have been in our February meeting. I also, in the last meeting, put together a unified document that really just incorporated what we had voted on and adopted at the previous February meeting, and included, I think, all of the other kind of language modifications that were suggested, with a couple of exceptions, mainly because I also ran a plain language over the document to make it as legible as possible. So, with that said, you know, I will open the floor. I would, you know, suggest, and when I provided, when the documents were going between the commissioners, I think we have a number of different files. The Commissioner Paul's red line that includes Commissioner Genorio's red line, I did go through there, look at them against the bylaws, the unified document that I had put together based on the red lines, and annotated Commissioner Paul's red line back to that, what I said called a cleaner document, just an updated document, so that you could track the changes that were made and adopted and what have you. So with that in mind, you know, my brain working here, so I would suggest one of a couple of things. Either we can go through Commissioner Paul's red lines line by line and vote on each of them, discuss them, do that. Obviously, that will be a little bit slower. Or we can go to the draft that I put together that I think reflects that, and, you know, point and click the couple of things that perhaps I missed. I'm open to suggestions on how y'all would like to do that. Commissioner Fast?
Yeah, Commissioner Paul, what would you prefer? Because I think I'm looking at both, and I want to make sure that we're not jumping over edits that you've made.
Well, I tend to be of the opinion that bylaws are, should reflect language that's similar to language in charter. That's how I feel. For example, I do think that even like on the first thing where legal authority, establishment and legal authority, I think that it is important to say that as opposed to saying who we are and where our authority comes from. Yes, those do mean the same thing, but I do tend to feel that it is important for bylaws to look like bylaws.
Okay. And so, did you want to go line by line on these, or were you just pointing that out as something you'd like to change on the unified document?
Well, I think going and changing the entire unified document is probably a fairly time-consuming. There probably aren't that many areas of real strong contention. I mean, the guiding principles that which I made significant changes to, the guiding principles are literally the words that were spoken at the commission retreat, almost word for word. So anything that was said in terms of guiding principles that people put as a post-it note on that information or wrote on that on the sheet of paper, those were then transcribed by the facilitator, and those were put into a spreadsheet that I created, and those were the guiding principles. So they're not. I don't know that there would. I don't know. Perhaps there are others that would have that would not feel good about what lines, 2.1 through 2.6. So I don't know if it's really all that difficult. I mean, the last page 6, really doesn't really say too much, and perhaps it really isn't all that complicated if we just go page by page, but
Okay.
it doesn't matter to me if people don't want to do that, you know, and you have another suggestion. As I say, 2.1 through 2.6 are pretty much, I don't know, maybe people do have some differences with what that says.
Okay. Well, I'm going to suggest, oh, I'm sorry.
I was just going to say, I apologize, my computer is dying, so I'm trying to look on my phone. It is small. I only had 2 kind of substantive comments, and they're farther than 2. So if you wanted to go through by item, I'm fine with that. Otherwise, I'll just hold my comments.
Okay. Commissioner Cox?
I'm just not clear on exactly where we're at on what's on the table, because I've seen and had the red line version of Commissioner Paul. I don't really know how that comports with your later amended version, Commissioner.
Okay. So.
Chair, so.
Sure. So I'm going to suggest that using the draft that has been noticed, and this is from January 26th, it's the file that I have is draft bylaws 1-27-26-KP edits -red line, including JG edit as noted. Okay? So that would be the last document that Commissioner Paul provided that has red lines. Now, I have, I believe that as we go through, I'll indicate where I think those have been already put into the full document, but we can do this line by line. And what I'll do is, Commissioner Paul indicated that, you know, she preferred a more formal construction of preamble and authority, and that's fine. You know, I personally disagree with that, just because, and I, you know, told y'all, pointed out before, and the last time we discussed these, that, you know, not everybody has the same level of reading comprehension that I do, that many of my colleagues do, and that if we are going to be accessible to the entire community, that I do believe it's an equity issue to make things as clear as possible, if the substance isn't changing. So, but, you know, I'll let y'all think about that and come back to it, because I think the red lines are more important to the immediate now. And what I'll do is I'll just go through this document, and I'll go through it to every red markup that I see, and I will ask for any comments, and we can then just vote on them as they come. And if anyone has any language suggestions or modifications as we go, we can discuss them in that regard. That's the only way that I can really see to do it in an organized fashion. Yes, Commissioner Paul.
Commissioner Fast asked me a question, and I answered the question as I would see it. That doesn't mean that everybody agrees. And if others want to use a more informal version, then we'll use the informal version, and I will make changes on that, which is fine.
Okay.
Or I will propose changes on that. If that's what people want, then that's what we'll do.
Okay.
I found the one without the red lines easier to look through. I kind of just kept a list of what we had discussed and did not look at the smaller changes. That was easier for me to do that, because I am terrible with editing in Word, etc. I can't ever get that to work properly for me. So that would be easier for me to review if there are substantive comments to that. Personally.
Well, then why don't we just go with that?
Okay. Then what I will do is, as I understand it, and please correct me if I'm wrong, what I'll do is I'll just move that we do a review of the document that I have, and it's been sent out to the commissioners, and I have it labeled as BPC_bylaws_clean 4-20-2026. And would ask the commissioners to, we'll just start with the preamble and authority. Commissioner Paul, would you like to discuss in a little more detail your perspective on Section 1?
Well, it's not just up to me. I mean, if there's others that have,
No, I understand. I'm just trying to give you an opportunity, as we go through this in an ordered way, to explain. If you have a further explanation, maybe you don't, but just trying to give you an opportunity to.
no, I don't.
Okay.
Not on one, no.
All right. Okay. Is there any other commentary on the preamble and authority in Section 1 to make any modifications? Okay. And as we go through this, I will rely on my fellow commissioners to make motions to modify things if you feel strongly about it. Okay. Moving into Section 2, guiding principles. Does anyone have any modifications or suggestions they would like to make at this time?
I do. I would replace the wording on 2.2 with the wording that I had proposed.
Okay. And the wording in the document that we are going through right now is 2.2, come to meetings prepared, having reviewed materials ahead of time, and be mindful of time and consideration for others. The language that, again, please correct me if I'm wrong, that I believe Commissioner Paul would prefer is 2.2, come to meetings prepared for open and engaged discussion, having reviewed material available in advance, being mindful of their time speaking, and always assuming the best in one another. Is there any, Commissioner Paul, are you making a motion to, well, I guess discussion would be first, I suppose. Is there any discussion from the commissioners about that proposed modification? Okay. My only comments about that, and I put it in some of my, oh, I'm sorry, did Mary have her hand up? I didn't see.
I would just say I agree with all of Karen's changes. And so I don't know how to speed this up other than going sentence by sentence. But I agree with her changes.
Okay, all right. And, I appreciate that, and I understand, I think I understand, why that would be important for some people to have, just being mindful of the time and speaking and always assuming the best in one another. My perspective, and it's kind of a minor point, but, again, that language is a little verbose for my taste in terms of drafting legal documents. I don't think it's as clear as the cleaner version. And, this, may sound pedantic, but lawyer that I am, and always assuming the best in one another, I find to be a little more on the lines of policing people's thoughts. And so, while I agree with that as a general proposition, the language that kind of assumes or tells people how they should think about things, I frequently find problematic. But again, just a minor preference, but with regard, and because I really do think that consideration for others really encapsulates that in a cleaner way. But my colleagues may disagree. So, Commissioner Paul, is that your motion to modify the 2.2 language to the redlined version in the alternative document?
Yes.
Okay. Is there a second?
I second it.
Okay. All those in favor, I guess it might be easier to just poll. So Commissioner Fast, I assume you are in favor?
Yes.
Okay. And Commissioner Paul,
Yes.
you're in favor? Commissioner Janorio, are you in favor?
No.
Okay. Commissioner Cox, are you in favor?
Yes.
Okay. Commissioner Finneran, are you in favor? Commissioner Finneran? We can't hear you. You're muted. Commissioner Finneran?
She said she has a fire alarm going off.
Oh, gosh. Okay.
I don't think we're going to get a quick answer.
I don't think we're going to get a quick answer. All right, well, let's table that, and I'll just put a note here.
I'm not ferociously opposed, I just don't really have an opinion either way. So
Okay.
I think keeping the one that I reviewed is
Okay.
where I'm basing my opinion.
For sure. Commissioner Cox, yes?
So the reason that I actually really like the way that Commissioner Paul said that is because, I don't know if you recall, but there was a previous commissioner who would get quite contentious especially during executive sessions. It got pretty ugly sometimes. And I was accused of, among other things, of being a Republican, which I'm not. I was cursed at, which I didn't enjoy. And I think that if everybody just tries their best to assume the best of other people, that things work out a lot better. That's all.
Okay. Thank you, Commissioner Cox. Other than that, are there any other modifications to Section 2? No? Okay. Well, and perhaps, as I think about this, because Commissioner Finneran is quite clearly indisposed, and we may well be needed to be taking votes on other things, I'm going to suggest just like a 5 to 10 minute recess to give her an opportunity to have an opportunity to come back. I don't really see another way to do it without excluding her from the discussion. Yes, Commissioner Cox.
We have a quorum without her.
I understand. We do have a quorum. We can just go ahead and do it like that. I would move for a brief recess of 5 minutes just to allow Commissioner Finneran an opportunity to come back and join us. Is there a second?
Second?
Okay. Commissioner Fast, what say you?
Sounds good.
Okay. Commissioner Paul?
That's fine.
Okay. And myself, I say aye. Commissioner Janorio, you say aye. Commissioner Cox, what say you?
Aye.
Okay. Then we will take a brief 5 minute recess. Thank you.
So, Commissioner Finneran is actually going next door and should be with us in a few minutes. There's what? On this floor, no. If you go downstairs, there's a really, yeah. There isn't another one.
Okay, I believe Commissioner Finneran has had an opportunity to get back to her computer. I know she had a few things going on all of a sudden. That happens sometimes, so I'm going to go ahead and call us back to order and put us back on the record. So the last thing we were voting on, just to rehash, Commissioner Paul had made a motion that was seconded to modify the language of the clean draft in section 2.2 to the language that was in the 127-26 edits to now read, "Come to meetings prepared for open and engaged discussion, having reviewed material available in advance, being mindful of their time speaking, and always assuming the best of one another." I had an aye, and please correct me if I'm wrong, I'm just summarizing. I had an aye from Commissioner Fast, an aye from Commissioner Paul, a nay from Commissioner Janorio, an aye from Commissioner Cox, and Commissioner Finneran. What say you, yay or nay to modifying 2.2?
Yay.
Okay. My vote would be no, but it carries, so very well. We will put that over there. Let me make a note on the document. All right. Now, any other modifications to section 2? Okay, hearing none. Moving on to purpose and goals, section 3, what the commission does. Are there any offers of modification to that language? Yes, Commissioner Paul.
I would ask that the wording that was deleted be reinstated.
Okay, that language being, so the current, or I shouldn't say the current, I'm sorry. In the bylaws clean version, the language is, the commission's job is to carry out police oversight, policy review, disciplinary appeals, and community accountability responsibilities that the city council and the law have given it. The modification that Commissioner Paul is suggesting to reinsert language that was deleted, that is, I believe, that includes, while preserving the operational authority of the chief of police except where otherwise provided. Did I get that correct, Commissioner Paul?
Yes, that's correct.
Okay, thank you. Now, is there any discussion on that from the commissioners?
I mean, I think I noted I was the one that wanted that removed, so just to be on the record.
Okay. I don't have a problem with it being removed, frankly. I don't think it really adds anything to the language in section 3. Because the authority of the commission is conferred by law, whether the law preserves operational authority or does not, and I think as it manifestly does, I would suggest that that is surplus language and is not needed. I understand Commissioner Paul has made that motion to modify that language. Is that correct, Commissioner Paul?
Yes, I have. I mean, I think that it is important to note that there are operational authorities that the chief of police has and still has that are provided under the law.
My just opposition to that sentence was in regard to the ballot item that Burlingtonians passed that will probably not get signed into law by Phil Scott, that would give the police commission additional authority, is that it seemed to me that those movements to add authority to the commission, that sentence was in opposition to that it is evolving and changing and could change our authority over that. So that's just my basis for that.
Sure, and I can certainly appreciate that. Yeah. And you know, and again, you know, the language where except or otherwise provided, again, is, from a legal perspective, is duplicative with conferred by law. Because when you say except as or otherwise provided, the question then begs itself in the document, provided by where, provided by what, provided by whom. And so, you know, that is an ambiguity in that language that, you know, I think could impact the document negatively. Commissioner Cox.
I was just going to say that supposing that ballot initiative was ever enacted into law, then that would be something that would be otherwise provided. So it seems that there shouldn't be a concern. And I think that it is useful for us to remember where operational authority lies. And it doesn't lie with us, it lies with the chief. So that's why I'm for the change.
Yes, Commissioner Paul.
I mean, this language was in the draft that was given to us back in January. So, I mean, I didn't make up that wording. I just kept it. You know, Commissioner Genoria wants to remove it. That's fine. Certainly a difference of opinion. But again, I didn't insert that language. That language came as part of the draft.
Okay, but are you moving to insert that language now?
Yeah, I
Okay.
thought I did, but
Okay.
yes.
And do I hear a second? Okay, that
I
motion.
second.
Okay, Commissioner Cox seconded. Commissioner Fast, what say you? Yes to inclusion or nay?
Can I abstain?
Sure.
Okay.
Okay.
I would love more information, but
Okay. Commissioner Paul?
Yes.
Okay. Commissioner Genoria?
No?
Okay. Commissioner Cox?
Yes.
Okay. Commissioner Finneran?
Yes.
Okay. And, well, let's see, that would be abstain. Okay, so I would be no, but that would carry because Commissioner Cox, Commissioner Paul, and Commissioner Finneran agree. Okay, great. So I will put a note on the document to add that. Okay. Any more comments about Section 3? No? All right. Section 4, are there any comments on that? Hearing none, I will move on
Now,
to...
wait. Can I ask, because I don't know that I'm looking at the same version. I'm looking at a red line version. So could
Okay.
you just read it, please?
So we're looking at the document BPC_bylaws_clean 4-20-2026.
Thank you. That doesn't help me. Could you just read it, please?
Yes. Section 4. Commissioner Cox, you wanted me to read Section 4, is that correct?
Yes, because I have the red line version in front of me.
Okay.
So I'd just like to
All right.
see if it's the same. Thank you.
Right, so I'm reading from the clean version as was agreed. So Section 4, Commission goals. The Commission's goals are to, 4.1, promote fairness and equal treatment in public safety. 4.2, support transparency and accountability in policing. And 4.3, give the community a structured way to provide feedback and oversight and to help build trust between the Burlington Police Department and the public.
Would it be helpful if we put them on the screen?
If it's possible.
Does someone have the ability to do that?
Is Scheib still with us? Okay.
Okay.
It does not look like
Okay, never mind.
that. Okay. So, based on that language, okay, great. Who's sharing their screen? Is that Commissioner Cox? Okay.
Not me.
Okay, Scheib? Okay, great. All right. So, Scheib, are you also able to share a side-by-side of the other? Of the BPC bylaws clean 420? Okay. All right. So since Commissioner Cox has the red line, I'm going to ask that the BPC bylaws clean be posted. And side-by-side's fine, if everyone can see. My vision is not that good from here. Commissioner Cox, does that help you at all, since you have the red line?
It's
And this
too
is
small.
This is the BPC clean that we're going through.
That's better.
Okay, all right. So that, do you see section 4 there?
Yes.
Okay. So does anyone have any comments with regard to section 4? Okay, no modifications. All right. Moving on to powers and responsibilities, section 5. Are there any comments on that one?
I'd like to ask what there was a thing that was inserted under 5.3 that has no number to it.
There is, yes, you're absolutely right. Thank you very much. And honestly, I don't remember. Let's see. Here, let me.
That is almost word for word 5.3 of the original.
Of the original, right. And now 5.4, now the language is a little bit different, but substantively it is pretty much, I think, identical. So the 5.4 of the clean, hear appeals from police officers or employees who believe the police chief unfairly fired, suspended, or demoted them. The commission may uphold, change, or reverse the chief's decision. The old language, hear any appeal of a decision by the police chief to dismiss, suspend, or demote an officer. The Board of Police Commissioners shall hear any appeal filed in a timely manner with respect to such actions of the chief and may affirm, modify, or vacate the decision. The 5.4 in the clean version substantively is the same thing, but the language from the previous version, it's a lot. And it's a lot for, I would say that it is a lot for people that are not familiar with that type of language. And, you know, like timely manner is surplusage because that's manifest to jurisdiction. And then affirm, modify, or vacate are terms of art, whereas uphold, change, or reverse are, you know, easier for people to onboard. So, and I put that there at the time just to kind of, because it was more of a substantial change in the language than others were. But yeah, I would, well, I guess I don't have a motion, we're going through this. I would prefer to use the 5.4 in the clean version, unless there's objection.
I think that before we make a change like that, that we should run that by the union. I think before we make a change like that, because this specifically spells out perhaps in legalese, and given the fact that there is a union contract, I would want to know that that was something that they supported as well.
I mean, okay. I find that I just don't see any nexus with this kind of language in the bylaws and the union, because it simply states what we do. But if everyone wants to table this for another, we would have to table the decision on the bylaws for another month to check that out. And I cannot imagine for the life of me that there would be any union nexus.
Perhaps there's just simply, if the chief, do you see any challenge with one versus the other, and whether or not that we should, and we can vote on the rest of this and just leave that one thing empty if we need to, but if you would have an opinion.
I mean, I think there's two things afoot here. One is, what is the intent of the differing language? I think the union may take issue with that, or the union may also just take the firm position that their contract spells out their rights, and they may not concern themselves with the language of the commission. But certainly, as we look to continue our constructive working relationship, if that dialogue were had, I'm sure it would be appreciative.
Thank you.
I guess my question would be, regardless of which version we had, if the union contract changes and our purview changes, the bylaws would be void on that topic. So I think would prefer something like simpler with less things in there that could call it into question in the future, instead of potentially, as you said, Karen, taking it word for word out of it because was certainly most accurate now, but could change? Or is that a problem if it changes, or would it just be void?
I mean, you can amend bylaws at any time.
Yeah.
Yeah, I mean, you can amend bylaws. I mean, it would, if there was some modification to the CBA that ran counter to the bylaws, then whatever that section simply, we wouldn't be empowered to execute it, essentially. So you would need an amendment. I mean, I'll be honest, I am a little troubled by the idea of engaging the union on an oversight body's bylaws when we don't, like, when this is a very plain description of what we do by statute and ordinance. You know, I understand if my colleagues, you know, prefer to table that for the union, but I am against it. So, Commissioner Paul, are you asking to table that particular issue to engage the union on it?
I mean, I think it's just one clause out of many, and I think it is important to have a collaborative relationship with the union. I mean, it's not really it's not going to really hold us up. We maybe can't vote on the bylaws as a whole with 5.3 missing, but I think we can do just about everything else. So
I mean, we won't have bylaws for another month, is what it'll amount to, you know, and.
Well, I wanted to do this last month and it was tabled. So,
Well, it was,
you know.
but I don't think that's necessarily germane. I mean, you know, we won't have them for another month, which if that's the outcome that, you know, my colleagues would like, that's fine. But, you know, the union does have a collaborative process, and that process is negotiating their contract. And that, you know, we are obligated to follow what's in that contract, we're obligated to follow what's in the statute, and so long as our bylaws reflect that, I don't see any reason, I mean, and to your point, that we can amend any time if the union were to raise some material issue with either language. We could modify that down the road and still have operating bylaws later on tonight.
I would just ask that we vote.
Okay. So is there,
I'm sorry, are we voting to
table that issue?
to change 5.3 or 5.4 to the red line? And if we did that, Karen, would that mean that we don't table it? Because I'm fine with that if we don't table it.
Yes, I would prefer not to table it. I would go with the language that was originally in the bylaws, but if people have a concern about not doing that, then I guess we would have to do that if we can't all agree. Perhaps other people have a suggestion.
Yes, Commissioner Cox.
So Chief will have to correct me if I have this incorrectly, but I think usually when they file a grievance and want a hearing, that the main issue is that we do this as soon as possible, so they're not like left hanging. And so that's not in there, but I guess I think that it may be useful to have just a comment in there to that effect, that may be exactly what they're looking for. I'd be interested in the Chief's thoughts on that.
Okay.
The timely manner
Yes.
portion of the red, yeah. Okay.
That was really the majority of why I wanted to keep the language. I do think that a timely manner does matter.
Well, but it's talking about, so here's the question then.
Well, we asked the chief.
If I could finish, please. The question then, on that language, the Board of Police Commissioners shall hear any appeal filed in a timely manner with respect to such actions of the chief and may affirm, modify, or vacate the decision. So, does timely manner, is that modifying appeal filed?
It should go after here?
Or is that modifying shall hear? Because as currently drafted, that is ambiguous.
Well, I think the last thing we were doing was asking the chief, so if
Well,
you want to ask. I mean, I don't know if you are asking me or exactly what you're asking.
Well, I'm simply asking that if Commissioner Cox is saying that timely manner is important, then I'm just pointing out the ambiguity that exists in this construction. And so and this is, kind of the difficulty we're in. So if we want to table, if I could please finish, if we want to table the matter, if there's a motion to table, we can do that. If there's a motion to modify, we can do that, or we can discuss. If you would like to hear from the chief as to whether or not he thinks that's ambiguous, that is fine.
I believe Commissioner Janorio asked the chief.
So if the question remains, the value of the language of timeliness be included, I do believe that is of value, but there are timetables associated with the grievance process outlined in the collective bargaining agreement.
Correct.
So I would make a motion that we take the second sentence that is in the red line version, the commission shall hear any appeal filed in a timely manner with respect to such actions of the chief and may affirm and may uphold, change, or reverse the chief's decision. That would be my motion.
Okay, so
from the word "the commission" in the second sentence, that line would be replaced with "the commission shall hear any appeal filed in a timely manner with respect to such actions of the chief and may uphold, change, or reverse the chief's decision."
Okay, so my question with that, again, would be, is timely manner modifying "shall hear" or appeal filed?
Yeah, would you be open to a friendly amendment that the sentence says, "in a timely manner, the commission may"?
That's fine.
Okay.
Okay. May hear, so that would be the Board of Police Commissioners or the commission. I mean, are we going straight to the red line, or are we modifying the clean of 5.4?
Well, what I had said was the commission.
Okay, so then we're modifying the clean of 5.4, so that would be then the commission, I'm sorry, Commissioner Janorio, you had that language.
In a timely manner, the commission, and then...
In a timely manner, may uphold, change, or reverse the chief's decision?
Is that correct, Karen? I think that incorporates both parts.
In the interest of moving on, yes.
Okay. And I will delete that, put that in. All right. Into section 6, officers of the commission. Are there any, and I think section 6, I think we already voted on, but are there any modifications?
I don't believe
to
we
section
voted on
6?
that.
Well, the chair and co-chair and vice chair,
I'm talking about 5.3.
Oh, okay, I'm sorry, I was talking about 6. All right, so we're going to 5, you're right, we didn't vote on 5.4. So I'll just make the motion to modify 5.4 to the clean version with, after in the second sentence, the commission in a timely manner is the modification, may uphold, change, or reverse the chief's decision. Is there a second?
I'll second.
Okay, thank you, Commissioner Paul. Commissioner Fast, yea or nay? Yeah, okay, Commissioner Paul?
Yes.
I am yes.
Yes.
Yes. Commissioner Cox?
Yes.
Commissioner Finneran?
Yes.
Okay, that carries. Moving on to section 6, officers of the commission. Are there any modifications to that?
We had already voted on that.
Yes, ma'am. If there's no modifications to that, moving on to section 7, duties of the chair or co-chairs. Is there any modification to that?
I have a discussion
Sure.
item, kind of relating to 7.9. Make sure no major policy recommendation, complaint decision, or communication to the mayor or city council goes without approval from the full commission. I just wanted to generally discuss what we think approval is, what we want that to be, and if we want to spell it out, if it's a simple majority, if it's 2/3, if it's a consensus, and if we want to have that be different for the different situations laid out or not.
Where is this?
7.9.
7? Okay.
And are you proposing laying out those different situations?
I don't know that I have a particular opinion personally, if I think we should need a simple majority, 2/3. I don't know that I have a specific opinion of that, but it's not clear to me what that would mean, and especially, you know, in situations where we would have something like somebody reaching out to the chair to provide comment or something along those lines, and say, however we are discussing that, do we need, you know, if it's in between meetings, do we need to have some sort of consensus via email? Is it something that somebody is just allowed to do that, and whether or not their signature is added to it?
Sure. I mean, it's a good flag. It's a good point. I guess my initial thought would be that, you know, if it's, most things are going to happen between times, obviously, that we meet. So my impulse is that, well, you know, if we can put together a majority consensus individually over email, then that would be one way to do it. And then regardless of consensus or no, then put it on the agenda for the next time to discuss it publicly. You know, if we have a consensus and we send out a policy recommendation or something, or a complaint, whatever, you know, then we would still talk about it in the publicly warned meeting to essentially ratify it. And if there is no consensus, again, put it on the agenda, put it on the publicly warned meeting to then debate it. Even if there is no move, would be my impulse. But I'm certainly open.
Yeah, I like that idea. Sorry, Commissioner Paul, if you were going to jump in.
No, that's all right.
I like the idea of having majority and then bringing it to the agenda for the next meeting, because then at least we can move things along in between. I like that proposal.
Yes, Commissioner Cox.
So the one thing we just need to be careful about is to remember to comply with the open meeting laws. So in the past, it's been handled if it's between meetings, if something important needed to happen, then we just done it by individual conversations between the chair and individual members, and then it was a majority.
Thank you. I appreciate that that perspective, Commissioner Paul or Commissioner Cox. So what I will do is I will move then to add a section, I guess 7.10, or
Can you just, if we're kind of in
third
agreement
sentence.
of what you said, maybe to approve by simple majority, something along those
Is
lines?
this 7.9?
Yes.
7.9.
So you want to change that to say what?
Approve by simple majority.
Okay, that makes sense. I see what you're saying. And then we have the option, the flexibility to do it in whatever manner is legal and makes sense at the time.
Right. Just so that it's clear to people in the future how many people need to be in agreement with something for it to come as a statement from the commission. That is my motion, I guess.
Well, I guess I'm trying to understand without approval of the commission as a whole. Again, that was in the original draft. That wasn't something that I came up with. I think that.
So are you saying that you think we need to be in 100%, everyone needs to vote yes for, or that is what you would like to happen?
Well, I'm not sure I really had thought about it. That was not one that I didn't have a change to that, so I didn't really, I didn't really think about that. It sounded okay to me.
I think in our recent discussions, it hasn't been clear to me, what we feel as a commission is enough people to be on board to say that something is coming from the commission and not just the chair's opinion or an individual person's opinion, especially when we're conveying that to the mayor or city council or about something important. So that's why I flagged that as being important to me, and especially if, you know, the next police commissioner that comes on board would have an expectation of knowing if it's majority, 2/3, or a complete, you know, consensus there to have a more official document like that go forward.
So I would suggest the language change to be, make sure no major policy recommendation, complaint decision, or communication to the mayor or city council goes without approval from a majority of the commission.
Yeah, I don't know that I would be in favor of that. I would think that it should be a little bit higher bar than that.
Okay.
I think what I heard you saying, Commissioner Depler, is that you wanted the majority to happen in between sessions. So then we could have a conversation, whatever it may be, about a policy, about whatever we're saying, and then bring that as an agenda item for a vote, but we haven't like decided what percentage of that vote.
Essentially, yeah. I mean, so the way I'm constructing it, and Commissioner Janorio may have a different way, but the way I'm thinking about it is like, you know, if we have something that comes up that is between sessions, that, you know, in line with open meetings law, it is possible to collect consensus, so that so long as that consensus is not collected essentially in a quorum, right?
Right.
And so to the extent that we need communication from the commission with, you know, in an official capacity, that the chair or whoever's collecting the consensus, co-chair, whatever, can collect that consensus outside of the meeting, right? So just for example, say, we have 7 of us, I know I've got 4 commissioners that want to do this, right? So go ahead and do that. And then you bring it up at the next meeting to essentially vote on it and would effectively be a ratification.
Yeah.
Right?
That's
Or if you can't get that consensus and you don't have 4 commissioners who want to do it all at once, so you can't speak with one voice, that's fine too. Also bring it up in the next commission meeting so that it can be debated and discussed. That's the way I'm constructing it in my head.
I don't think the open meeting law allows for consensus by email in that way.
Okay, I appreciate that perspective. Is there any other discussion on the matter?
So is the goal then for us to think about the threshold for what the approval might be? Is it a 2/3 majority of the commission instead of full? Because I agree with.
I mean, you could. I mean, if you did 2/3 majority in this language, then that would run over the top of complaint decision. And so we've got different standards, I think, for complaint decisions that does not require a 2/3 vote. It would only require a majority. So if we wanted to go to a 2/3 vote, then I would suggest that we blow that out into a separate section that, you know, articulates that for, I don't know, policy recommendations or official communications to mayor or city council, then you would need a 2/3 majority, which effectively is the difference of 1 person. It's 4 to 5. What do y'all want to do? I mean, I think the majority of the commission, just sticking it in 7.9 is the cleanest way to do it. And so that's what I would move to do, and modify that language to make sure no major policy recommendation, complaint decision, or communication to the mayor or city council goes out without approval from a majority of the commission, and leaves how that approval is achieved essentially to the exigency of the circumstances.
So my only concern here is just simply that you know, again, I'm not an expert on the open meeting law. I do think that gathering consensus by email, I think actually is the law. I believe that is, you can't do that. So doing something in between a meeting would not be, I mean, you can have as many conversations as you want, but you can't use that to build your consensus and then go and issue a statement. I don't, and say, on behalf of the commission. If you want to keep it with a simple majority, then I would just simply add the words that, those that are, and I would say that, to give the option that those who disagree with the majority can be stated by name.
Okay.
And I believe that Commissioner Cox has a comment. Sorry. to
Yes,
interrupt
Commissioner
you.
Cox.
Yeah, I just want to make sure everyone's aware of the time limitations on what our decisions are on complaints, because we have 14 days from the date we receive the chief's determination. But if we want more information, like for example, we want to view body cam footage, we have 14 days from the day we receive the additional information to make the decision. And so it's been done by special meeting, it's been done, different ways, but I just wanted to alert people to the fact that the complaint handling is different than these other things.
Okay, thank you.
My other comment does relate to that section as well, and kind of
Sure.
how those two interact, so I don't know if now's a good time to bring that up, and then maybe that would tell us whether or not we need to break these out into different
Sure.
sections. Shai, would you mind scrolling down to section 14.3 really quickly? So we have in there, if a majority of the subcommittee, yada, 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 if there's only 2 commissioners on the complaints committee, a majority is question mark 1 person, which means 1 person can decide whether or not this goes forward, and then they're responsible for drafting a recommendation. I don't know if that's the intent of that scenario and if the commission is okay with that.
Well, the majority, when you have 2 people, the majority is effectively unanimous, because to get to 51%, you would need more than just 1 person.
So if 1 person then disagrees, then that kills it.
Yeah.
And I feel like perhaps this, should be changed such that everybody on the commission still gets a voice in that maybe the subcommittee members are responsible for these things, and if anybody has a doubt, they could raise it, but that doesn't mean yes or no if that happens.
Yeah, I mean, I would at least, just carrying on with that thought, I would say that I would suggest a 14.4 change, like an addition to as a 14.4 that articulates that if you only have, or if you have like a 50-50 split on the subcommittee, that, that split itself would be elevated to the commission to determine.
Okay.
I mean, if that works for you. I mean, I get what you're saying. Like, I think it makes sense. Like, people should absolutely have a voice. And if there is a difference of opinion that prevents action, then I feel like that's something the commission would be appropriate to engage with.
Yes. And then I guess in furtherance of that, if people are in agreement that that is not the intent of that, then going back to Section 7, maybe the complaints part is removed from that because that's dealt with in Section 14?
Could I speak for a second?
I'm sorry, what was that, Mary?
I'm sorry, I'm losing my voice here. But so the complaint process is in our policy and in a department directive, and it provides that the commission will vote on the determination once the chief does make a determination on a complaint. And so I don't think that, I guess this is the first time I'm seeing this version where we're just possibly, what if there's 2 people that just think that everything the cops do is fine, and there's 2 people that think that the cops are wrong no matter what they do, that would agree with each other but not agree with the full commission. And the full commission is what's referred to in our own policy and in the department directive. So I just would disagree with the provisions of 14 point. for whatever it is.
Well, in 14.3 does articulate that, let's see. Final recommend, okay. Drafts a recommendation, brings it to full commission. Yeah, I would suggest that 7.9 is not as related to 14.3. I would say that, I would suggest that we take up that particular issue when we get down to 14, because 7.9 really is talking about full commission action. And 14.3, while it is specifically about the complaints subcommittee, does articulate that, and as Commissioner Cox points out, we already have requirements with regard to how the commission can vote and the number of people that must vote on complaints. So I would encourage us to deal with that when we get to 14.
Okay.
And then, so 7.9, I would move then to modify that language to include a majority of the commission. So the language would change from make sure no major policy, recommendation, complaint, decision, or communication to the mayor or city council goes without approval from the commission, from the full commission. It would change to from a majority of the commission. Do I hear a second?
Second?
Okay. Commissioner Fast?
Aye.
Commissioner Paul?
I wanted to add that, in fact, it's in here in another iteration, that it would say, at the end, including how each commissioner voted. So if people are in the minority, that position is acknowledged.
Or abstain if they're not present?
Yes.
I guess that's not abstaining, they're just not present.
I mean, these could be very important policy decisions, and I think people should have the right to be on the record if they disagree.
Well, and I mean, that was my thought with regard to putting it on the agenda so that for the subsequent commission meeting, so that they could be on the record and could debate it fully. Let's see. We could talk about adding a majority of the commission and after commission with notation of dissenting commissioners.
Well, but if a commissioner is not there or a commissioner abstains, then that's not a dissenting opinion.
Okay.
I'm sorry, what you suggested, Karen, was just that everyone's vote be listed? Like with our,
Yeah.
if our names are on the bottom, yes or no? Okay,
Or absent or abstain.
yeah,
Okay, with
Yeah.
notation of commissioner votes?
yeah.
I mean, as I say, sometimes it may not matter, but other times it may matter.
Yeah,
Okay. Commission, okay, so it would now change to, from that original language, to from a majority of the commission with notation of commissioner votes.
I'll say yes to that. I mean, well, I don't know,
Okay,
you're
well,
asking.
let me
Go ahead.
move again to modify the language to say a majority of the commission with notation of the commissioner votes as modifying the language in 7.9 on the clean 420. Commissioner Fast? Commissioner Paul?
Yes.
yes,
Okay. Commissioner Cox?
Yes.
Commissioner Finneran? Okay, I think I heard an aye, and I am aye as well. So that carries. Section 8, duties of the vice chair. Are there any modifications to Section 8? Okay, hearing none. Section 9, we're moving on to meetings. Regular and special meetings, Section 9. Are there any modifications there?
Under item number 2, I do think that every effort should be made to consult with the commission before you go and cancel a regular meeting, so I would like that language put back in. So before the words "the chair," after making every effort to consult with the entire commission, so that no one feels that they have been, they have not been consulted. I mean, canceling a regular meeting is important, and it may be very difficult to get another date. So before something is canceled, I think there should be at least every effort made. Doesn't mean that it's going to work, every time, but I think that efforts should be made to consult with every member of the commission.
Sure. Well, I would argue that the 9.2 in the clean is actually stronger in that regard, because the canceling of a regular meeting is modified by after consulting with the full commission. So that mandates that the full commission must be consulted.
Okay, all right, well, actually okay, all right. All right.
Okay. Any other commentary on or suggestions on Section 9? Okay. Moving on to Section 10. Is there any commentary on that?
My only commentary on that is that, as I put in a note on 10.4, I'm not sure under what circumstances the chair would decide not to follow Robert's rules.
Mm-hmm.
If that is the rule, then that's what's followed. And I don't know why the chair would be able to unilaterally decide that we're not going to follow Robert's rules.
Yeah, and I think that's fair. So, you know, the stricture of Robert's rules in this situation would be a motion with no debates, an immediate vote, and a 2/3 vote would suspend the rules. That's the strict interpretation of Robert's rules. Doesn't bother me. We can just say we'll follow Robert's Rules of Order in order to do that. Or if you want more flexibility, then you would potentially lower that threshold or require a vote on a simple majority. There are situations, I think, where you might want to suspend the rules technically just kind of on the fly without a vote. For example, if someone in public comment has gone over their, 4 minutes or something like that, and do you want to have a vote every time to suspend the rules and do that, or do you want to have a chair or a co-chair be able to say, well, you can have a couple more minutes? I mean, and I'm not trying to be glib. That's just that is the horn of the dilemma as I see it.
I'm not familiar enough with Robert's rules to know whether or not anything would be succinctly against it, so I don't have an opinion either way.
Well, I think that's probably an extreme example. I mean, there are plenty of bodies that you go over by 30 seconds, and obviously nobody is going to keep on making a motion to suspend the rules. So, I mean, if you want to, if I could just finish what I was saying, if that is problematic, then we just keep the words in there.
Okay. Well, does anyone? I'll put it like this: does anyone have language that they would like to insert that would modify that? Okay.
I'm sorry, Karen, were you making a motion to remove the second clause?
No.
Oh, okay.
Okay. Now moving on to Section 11, public participation. Is there any commentary on that?
Well, we've already voted on that, so I think that whatever we have adopted should be in there, word for word.
Okay.
Unless we're going to go and start making changes.
Which is what I was asking, but apparently there is no one's offering that.
Well, there is, because it's not exactly the same as what we voted on.
Okay.
I mean, I just think that if we went to the effort of doing something in February, that it should be in there exactly as we adopted it. Now, if you want to go and revisit that and make changes to it, we could certainly do that.
Sure. I thought that was the language that was
Well,
that
the
was
word
adopted.
dialogue is first, and I think that dialogue is important. I think that people need to understand that, there's not going to be dialogue if you either understand it as back and forth or just any level of dialogue.
Sure. So all right.
I mean, I think that we voted on 11.2. Now, if we didn't
Sure.
vote on 11.3, then, I guess that's fair game. But I just think in the interest of time, we should try to not revisit the things that we've already spent time visiting.
No, I agree. What is identified as adopted was 11.2.
All right, well,
During
then,
public comment, each person may speak up to 4 minutes. The presiding officer may extend this time at their discretion based on the nature or complexity of the comments. Time limits may not be applied based on what someone is saying or their point of view. The presiding officer may only stop a comment that is patently offensive. If there are many speakers, the commission may shorten individual speaking times by a majority vote. That is all I see that was indicated as adopted.
Okay. I mean, I don't remember, so
Okay.
that's fine.
Can we put dialogue back in 11.3 at the beginning? So
Dialogue.
dialogue, comma, back and forth discussion.
Sure. Let's see.
Did you want to make a motion to do that?
Yes, please.
I'm just thinking about how to construct it. Okay. So how about dialogue and back and forth discussion with members of the public may happen only when the chair or majority of the commission approves it?
Yeah, that sounds great.
And is that your motion,
I would like to make
Commissioner
a
Fast?
motion to add
Okay.
that. Thank you.
Is there a second? I'll second that. Commissioner Fast, you're an aye. Commissioner Paul?
Yes.
Aye. I'm an aye.
Aye.
Okay. Commissioner
Aye.
Cox?
Aye.
Commissioner Finneran?
Aye.
Okay, thank you. Carries. Noted. Section 12, attendance. Are there any comments on attendance?
No, I think actually that wording is better.
Okay.
It's very hard to cover everything when it comes to electronic, so I think video conference is probably better than trying to cover everything by Zoom, by or by phone. I mean, now video conference, obviously, then you would have a camera. It is possible that people could attend the meeting by phone, and we haven't covered that, but maybe we don't need to.
Sure. Okay, thank you. Moving on to committees in section 13, standing and ad hoc committees. Are there any modifications to that section? Hearing none. Moving on to 14, Citizens Complaints Subcommittee. And Commissioner Janorio, I think this is what you were talking about in terms of 14.3
Yeah, I guess.
earlier.
So 14.1 says at least 2 commissioners shall serve. So assuming there are 2, then perhaps the language in 14.3 doesn't necessarily agree with our policy on how complaints are resolved, as what Mary brought up.
How about, just give me a second. How about on 14.3, adding a sentence that says, in the event a majority of the subcommittee cannot agree on an action, the matter will be elevated to the full commission to discuss.
You know,
Go
Chair
ahead,
Deborah,
Commissioner Cox.
Can I say something? I agree more with the original language in here, which said that the subcommittee shall draft recommendations. It says when directed by the commission, but it should be for every complaint that's determined, and which shall be subject to full commission discussion and vote. There's just no way to get around the fact that the full commission needs to vote on every determination that the chief makes. And so my understanding of the reason for the subcommittee is that they can look at the detailed work, decide, like, maybe we want more information before we are even comfortable making a recommendation, ask for more information, and before they even get a determination, for example. But the time limits start running, and the full commission has to act on each and every complaint determination. And so the way that this read, that it did read, and I don't know when this changed, but it did read, the subcommittee shall draft recommendations, and then it said when directed by the commission, which I think should be removed. Then it says which shall be subject to full commission discussion and vote. And that's really what the job is they can make recommendations and say, oh, this is a case such and such. We already looked at it in detail. But, you know, every commissioner during the entire time, at least I've been on the commission, has looked at all of the materials. So the recommendation is useful, but it doesn't stop the fact that each person voting should also be reading all the materials that are looking at footage or whatever it is.
Well, I appreciate that, Commissioner Cox. As I read 14.3 in the new version, because in the other version, there's only 14.1 and 14.2. And 14.2 in the old version indicates that, you know, as you indicated, the subcommittee members will offer a recommendation when the commission appoints, but that doesn't solve the problem that Commissioner Janorio pointed out, that if you only have 2 members of the committee, it's impossible to, it is possible that you could get to a no majority view, in which case recommendations would not be practically able to be sent to the commission, and you'd essentially have a hung subcommittee that can't provide recommendations. So
that's fine though, because as long as the commission, as long as you know that the commission as a whole has to vote on each one, then it doesn't, and if the subcommittee can't come to an agreement on what the recommendation is, that's fine. The commission as a whole has to come up with a majority vote.
Right. Yeah, and I appreciate that. And that's what the new 14.3 says, is that the recommendation is then voted on by the full commission, who can amend, vote yes, vote no, or abstain. And the final written recommendation, including how each commissioner voted, is then sent to the mayor's office. Any commissioner may write a separate minority recommendation. And in the event that a majority, and this is the new language that I'm offering, in the event that a majority of the subcommittee cannot agree on an action, the matter itself is elevated to the full commission to discuss. Go ahead, Commissioner Cox.
So if I may, are you talking to me or someone else?
No, yeah, please, Commissioner Cox.
Okay. The way I'm reading 14.3 is that it only comes to the full commission if the subcommittee disagrees with the chief's determination. And what I'm saying is that no, the whole commission has to vote on whether we agree, disagree, or want more information on the chief's determination. That isn't something only 2 people should be handling. It's so
Can
that sentence should be eliminated.
Can you reiterate, Mary, how that was done in the past? Say that, you know, you get a response from BPD that says, here's our decision. That's the day after the commission last met. Is it then simply that a special meeting is called and the commission and votes? So I'm kind of like, I'm unsure what the citizens complaint subcommittee is, if not a person who could be the co-chair or vice chair that is simply record keeping these and keeping on top of the tracker and making sure everybody has everything, because if the whole commission needs to be involved in these things, and it is time sensitive to the point that it is very likely that there'll need to be a special meeting, that it's kind of moot.
It is very much, in the past, it's been very much of a record keeping, but also making recommendations when one is able to be made. Sometimes they say, I'm not really sure what to do with this case. It's like when only one person was doing it, they would put the documents in the file, and then the only time that you had to act is when the chief actually made a determination. So then you'd send a note around, oh, we just received this determination from the chief. Documents are all in this file. The original complaint, any other investigations, the chief's determination, and then they would say, I've read this already and this is my thoughts, but every person in the commission has to vote on it.
Okay, so I'm going to suggest in the language that we're looking at in 14.3, we can strike if the majority of a subcommittee disagrees with the chief's response and simply add, so it would be subcommittee members review all complaints and the police chief's response, period. The subcommittee shall draft recommendations and bring them to the full commission, period. Then the full commission votes, blah, 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 blah. And then the last line being, in the event a majority of the subcommittee cannot agree on an action, the matter will be elevated to the full commission to discuss.
Okay.
Does that work for you, Commissioner Cox?
I think that's consistent with what's in our policy and what's in the department directive.
Okay, great. So I will move to make those changes as I just articulated them. Do I hear a second?
Second.
Okay. Commissioner Fast? Commissioner Paul?
Yes.
I'm a yay. Commissioner
Yes.
DeLorio? Commissioner Cox?
Yes.
Commissioner Finneran?
Yes.
Okay, excellent. Moving on to, is there any other discussion on section 14?
No, but not to get ahead of ourselves, but I would make a motion that we adopt the language that's in items 15, 16, and 17.
Okay.
Second.
Commissioner Fast? Commissioner Paul?
Yes.
I'm an aye.
Yes.
Okay, excellent. Commissioner Finneran?
Yes.
Commissioner Cox?
Sorry, yes.
Okay, excellent.
Okay.
Well, thank you very much for everyone's work. We have a set of bylaws. So what I will do is I will take these comments and I've already added them in for my notes. I'll add them, what I will do is I will send the red line of this to everyone to confirm that this language is what we voted on. And then once I get affirmatives back from everybody, then we'll put these together, and I suspect we will probably have to send them to the clerk, if I had to guess. But before we do that, we'll make sure that a final version is distributed and approved by everybody.
I don't know if the city attorney would want us to simply vote on the entire thing now that we've made all these amendments, or if this is good enough.
You know, if the city attorney has an objection, then I would suggest the city attorney to make it, but I would say we go ahead and vote on it tonight, just on the changes we made, and so that we can say that we did vote on them, and if the city attorney is unhappy with it, they can certainly make their perspective known. So I vote that we, as we have discussed, as we have amended, that we adopt the bylaws of the Burlington Police Commission. Do I hear a second? Second, Commissioner Paul. Commissioner Fast? Yes, Commissioner
Yes.
Paul? I'm an aye.
Aye.
Commissioner Arroyo? Commissioner Cox?
Aye.
Commissioner Finneran?
Aye.
Excellent. The ayes have it. All right. Thank you very much for your work on that. That was not easy to do. All right. Let's move on to the next item of business is a discussion about the Bodycam release, and Bodycam is a little non-specific, specifically the release of the Bodycam footage for BPD on March 11th of 2026. Is there, I mean, I'll start it off. We did ask for this Bodycam footage, I believe at our last meeting, which I believe was March 23rd or 24th, 23rd, I think. And that Bodycam footage was recently released to our body on April 20th. I was frustrated with the length of that time because I believe that should have been provided to us earlier under our authority in the city charter, in I believe it's 183, sections 183 and 184, and resolution 7.09. And so I was frustrated with the length of time that took, and at least to my satisfaction, was not provided a reason under the law or under city ordinance why that was withheld. Is there any, do any other commissioners have any perspectives or discussion on that? No?
I mean, I guess I'm in agreement, and it didn't seem clear, like in a lot of things, that there is a strict time that says within this amount of time such a thing shall be done. So I would be interested in trying to have some policy that makes clear what that is in these circumstances, unlike others where there are specific times that we need to, that we are duly to receive something, and then we have a time where and we need to respond.
I tend to agree. And this kind of, you know, goes into another item on our agenda. We had discussed as a body, an executive session, and then informally a open letter that was placed on the agenda. Yes, Commissioner Cox.
So I would just suggest thinking about perhaps talking to the chief or maybe the deputy chiefs, just more on a one-on-one basis, and seeing if we can't collaborate to come up with an agreement that will satisfy us and not make them feel uncomfortable with how soon after an event should they look at releasing the body cam footage to us. I understand the mayor needs to be involved on some of these big cases in particular. I know it's very complicated, but like I had mentioned, that there was this case from last September where a person was shot, and I would frankly like to see the body cam footage, but I was told it's still under investigation, and I was happy enough to just let it drop for now. I mean, my view on the case is going to still I'm still going to be interested whenever I do see it, but it is kind of frustrating, I think, in that case. So it's been 7 months, 8 months since the event, and we still are not able to see the body footage, and so body cam footage. So it would be nice, I think, to come up with some agreement if that's possible, but I always like the idea of trying to collaborate at the outset.
And I appreciate that, and I think that's a very good point, and I think it really goes to the point that I find troubling, which is, as you articulate, if the commission or members of the commission are trying to get body cam footage under their authority to, like in this case, to see if the officers are behaving in conformity with established policy, as the current resolution and city charter is written, there is no exception for an ongoing investigation. That our authority is broader than that. And, so I appreciate you bringing that up, that this is not an issue that is only coming up now. This is an issue that has been ongoing. It's simply quite acute since we have had this, March 11th ICE engagement. And, certainly, I understand not releasing to the public. There are legal exceptions for release that involve investigation. But those legal exceptions, at least in state law, do not apply to an instrument of the city, which, essentially the board, the police commission is. We are empowered by the city council. And so, there is no exception for that withholding. And so, and in the event, as you said, all you've been told is that there's an investigation. That was the same thing that the commission was told at the time we initially requested the body cam footage from March 11th. And so, in the absence of, a legally based reason, I do submit that it is very important for a legislative body, if we do not, and to the extent we are, because we are a legislative body, if we do not assert the authority that is granted to us by law, we will lose it. And the way we lose it is when the executive denies us information that we are entitled to when we ask for it. Go ahead, Commissioner Cox.
I honestly think that the best route to take is collaboration versus threats. And we went through the same sort of gyration when, under Chief Murad, we were regularly viewing body cam footage from use of force incidents. The union objected. They filed a grievance, step 2 grievance. We embarked, though, on a months-long negotiation, and it just took time because we only meet once a month, but it was took several months for us to come to an agreement that they were satisfied with, that also satisfied us. And that's the second, the most recent body cam footage policy. There's another one that has to do with other topics, but the policy that we can view body cam footage from just sort of a helicopter view. It's not for the purposes of discipline. It's the purposes for seeing whether and to what extent the police are, are being compliant with the directives. And it may be that the directives need to be changed. It may be that they start off complying with the directive, and then operational things just sometimes happen. Stuff happens when you're in operations, and so sometimes it's difficult to comply precisely with what the directive says. There's all kinds of things that can happen, but there's no way to even have to start a dialogue unless you can see the footage. But we came up with that agreement through collaboration. We had Zoom meetings with a few of the leadership of the union, their attorney, and us. We kind of discussed out what our intent was. They really just didn't want the auditing, the viewing of the body cam footage to be for the purposes of discipline. That was their main issue, because they're guaranteed that right to be free of audits for the purpose of discipline in their contract.
Sure.
And so
I'm sorry.
they were very nervous about why we wanted to see these, and it wasn't for the purpose of discipline. And so we hammered out this agreement, this agreed policy. And so I thought it was effective. I thought it was useful, and it actually engendered good feelings all the way around, and so that on future issues as they arise, we're able to have conversation and be able to say, I know those people, we've dealt with them, we've already collaborated, I know they're good collaborators. And the way we do that is by saying, here's another instance where we can actually start by having a discussion between the police commission and the BPD, if the chief is willing to cough up one or two of his people for the purpose of having a discussion about this.
Sure, I appreciate that. I don't see them as mutually exclusive. I mean, I think it's very important for a legislative body to articulate when it attempts to exercise its authority granted by law, and when that authority is not honored in a timely fashion. I don't see that as mutually exclusive with collaboration. In fact, I feel that that is essential for collaboration, particularly when you are talking about where the police commission sits. If we are to be any sort of oversight body, if we are to be any sort of voice for a community that, as we have heard today, has an impacted trust with their law enforcement. And Chief Burke, this is not obviously direct. You and I have had coffee before. This is not directed at you personally, right? And I respect Chief Burke's position and his love of this community, but the fact of the matter remains that as a legislative body that is tasked with certain oversight obligations, if we do not diligently and zealously advocate for our own authority, it will be lost. There will be no reason to collaborate with us because we don't care about our own authority, so why should anyone else? And in my mind, that is an abrogation of our responsibility. And so, I understand what you're saying, Commissioner Cox, with regard to collaboration. I think collaboration is absolutely a value, and I think it needs to be upheld. But I don't believe it is the only value. And in a situation like the one we had on March 11th with the community response that we had, we don't have, as a community, another party like in a union that we can kind of horse trade with, and what are your interests and what are our interests and how are we doing this, and come and have a put together thing. And in fact, I think in situations like this, the value to both the officers and to our community is to air these out. We have to discuss where these interests intersect. We have to have these hard conversations as adults, because I worry that if we just go behind get into a back room and sit down and figure out like what works for everybody, that to the community, that might not look like a deliberative, transparent process. And so, that's one of the reasons why, I offered initially this letter to the mayor and to the council president to ask very explicitly if this is the intent of the city council, that the police commission asks for something that believes it is entitled to under law, and that information is withheld on a timeline that is not supported by law. If that is the council's purpose, if that is the council's interest, if that is the council's intent, then so be it. But I think it is very, very important to articulate publicly that that is a tension that this commission has experienced in a situation that is of great import to the community.
Did you want to say something, Karen? I thought your hand was raised before. I don't see, at least from what I was witness to, that there was space for collaboration. I think what I experienced was we asked for something and the chief said, no, I'm going to follow this process. And then we kind of like took that no and came up with some other ways to discuss it. And I'm in agreement, Mary, that collaboration is the best way to do it. And I think we should definitely try to work forward as a commission and having some kind of policy document that prescribes what we agree is a reasonable amount of time to get this information. And if that has to go through the legal team on both sides to confer what that is, that's fine. I think we're all in agreement that we were miffed by how long it took for us to get this information, and now we have it, so that specific point is gone, and now the point of how are we going to do this in the future is important. I do just want to say that it didn't seem clear to me in our discussions of why we wanted this, that it was respected by BPD, why we wanted it in such a time frame. It was very important to me because at some point, and we've seen this from, it took less time for South Burlington and for VSP, who has significantly more information to review. They did redact and release it publicly on a shorter timeline. That, South Burlington, VSP, they don't have this kind of oversight body. Burlington does. That's what our voice is to do. And by delaying this justice, it ultimately is denied. And I know that doesn't, I didn't feel that was reflected in the comments that we got from the chief, that simply following this method that was prescribed by reaching out by the mayor, taking purview and reviewing, was respectful of the overall situation. That's kind of why my feelings, why I was miffed about the situation. So that's all I got to say.
Go ahead, Commissioner Paul.
Thank you. So I do agree that we should certainly assert our authority. I think there's ways to assert that authority that may get you closer to the desired outcome. And I think the letter, the nature and just the overall nature and tone of the letter, to me, should be a next step after other means of communications have been tried. For example, I don't know, this letter was written. I don't know, and I would be interested to know if prior to writing this letter, any at all attempt was made to contact the city council president. If there was a conversation that went on before putting out this letter, was there any attempt to engage the council president and have a conversation about the concerns that are being raised and to see if there could be perhaps a way of addressing this before there was a letter?
Is it your opinion that the chair should do that without discussing with the rest of the
Anybody
commission?
can do it. I mean,
Okay.
any of us can do it. I mean, if it's important to you, if it's an issue that you care about, you pick up the phone and you make the call. You know, I mean, you're only speaking on behalf of yourself.
Okay.
You know, and until there's a vote taken, everybody is speaking on behalf of themselves. So, you know, my question is, I mean, you know, this was not something that I wrote or drafted or had any, I mean, I was asked for input, but I didn't give any input about this open letter. So I probably wouldn't be calling and asking. But for those for whom this was important, the question is, was there an attempt to have a conversation before putting out a letter? And, you know, and if that conversation was something to the effect of, well, the answer is no, well, then you've made that attempt. But if there's no attempt to either engage the administration or to engage the council president, we're all appointed by the council with the mayor presiding, and those people are part of our community. We see them all the time. It's not difficult to, you know, to make that call and find out if perhaps you could just have coffee and have that conversation before you would go and put out a letter. That usually is more, I think, a written communication, at least in the way I hope we would treat one another, should be maybe not the avenue of last resort, but I don't think the avenue of first resort. So that would be my question is, was there any attempt made to have that conversation?
Well, I mean, I would push back on the utility of that,
Well,
mainly
I'm just
because-
asking the
Are
question.
you asking each one of us?
Well, I mean,
I could answer for myself. I did not reach out to anybody because I specifically didn't want to seem like I was speaking for the commission when it was my opinion, and that's why I felt our discussion over email of what should be done was the appropriate way. If your opinion is that it is appropriate when I have an issue with the commission to reach out to the mayor or the city council president, that's fine. That was not what I found as the collaborative way to go about it. I know that you had forwarded us emails, that you followed up with the chief asking about the timeline, and I thought that we had heard like a no later several times. So that's what I was going on from that basis.
Yeah.
If we are in agreement that it is a way to go about things, as you said, then in the future, I certainly would do that with less reservation.
Well, I guess what I'm saying is that, you know, if something really is upsetting, and you're really, I mean, you've said that you're miffed. I mean, I don't know how bad miffed is, so I don't really know. I can't put that on a scale of 1 to 10. But I do think that as a small community, that having those conversations is not, you know, is certainly a good first step if it doesn't pan out to the outcome that you're hoping, or gee, let's have that conversation and let's get together and let's have one of the committees of the council take a look at this. You know, I just find it hard to believe that the council president wouldn't want to, you know, further have a conversation. But, you know, I think there's, you know, everyone has a difference of opinion about whether a letter is a good idea or not a good idea. I think if we are looking to gain a positive path forward, that having these conversations builds rapport, and you're probably going to get a better outcome if you have some level of rapport, unless, of course, you want to, you know, take this by legal means. But I think that would be rather difficult to do that, but probably, I don't know. I would hope that that would not be the outcome that anyone would be seeking. You know, and I do think that, you know, the public safety committee in 2021 is the one that wrote the resolution that everyone is quoting. I was one of 3 members of that committee, so I remember when that resolution was written, and there was nothing on there about the time, and we did discuss that at the time, and I think it was because there was a collaborative effort made to arrive at something that was more than what the police commission had at the time, and brought us one step closer to having greater oversight, which is what we were hoping to achieve, for the police commission to have greater oversight within what we could do. I mean, a lot of that would have to be changed by charter, which is why the charter change that you referenced before came about. Yeah.
Can I just ask, Chief, did you read that open letter that was as part of our agenda?
I did, and could I add one comment?
Yeah.
Thank you so much.
Yeah, sorry, I said something to you, and I don't know if I gave you a chance to say anything back.
Okay, no, I appreciate that. You know, I just want the record to be clear that, in my mind, this is like competing policy. And I don't in any way want to minimize the degree of harm the community experienced as a result of the March 11th enforcement activities. However, the policy is crystal clear on the workflow related to use of force complaints made by the public that garner great public interest. And that, in my mind, is a prevailing policy because it involves the executive of the city. So please know that was really, you know, where I was grounded at the time, and I relied on guidance from the city attorney's office, and I respect Chair Depper's interpretation of the charter authority, but I don't know which one has priority in any given circumstance. And maybe that's an area for clarity.
Would you find it somehow uncomfortable or in bad faith if we, you know, tried to resolve this legally so that we could have something in a policy that said, yes, this is within our purview, and here's some common sense timeliness guidelines about it?
The one thing that I would caution is and we'll use the use of force complaint scenario, is if you're examining a use of force case for policy compliance, that means you're making a determination before it's been investigated and adjudicated by the police department. So I don't understand how that can be done without subject matter experts applying law, policy, and training standards, and that would be a concern. And then the other point that I'll raise on behalf of the executive of the city is that, you know, the mayoral executive order that was issued in 2021, apparently it's not dated, seems to codify the role of the executive in that specific process, and I think that's important, and that official will have the opportunity to be read in on the investigation, provide recommendations, and then that body of evidence is brought back to the police commission.
In the situation of a complaint, correct?
Yes.
Okay, but not under the authority with regard to 183, 184, and Resolution 7.09.
But does that apply if there is a complaint? Like which policy prevails? I think
right,
that's confusing.
and I would say that's what we're like. So because the city council doesn't make that distinction, right? That's not and we had this conversation 2 months ago, right? I mean, I understand your perspective. My problem with it is that none of that is in the city charter or Resolution 7.09 with regard to our oversight authority with regard to directives. And so while I'm sensitive to your perspective on the idea that, well, it hasn't been adjudicated, it hasn't been investigated, correct, because the 7.09 authority that's granted to this body is not adjudicative. It is audit related. It is review related. It is, do we examine the language from like fair and impartial policing, for example? Do we examine it to see if there was any nonconformity? But we're looking at the language itself and how it plays out in real time, not whether or not someone did something good or bad, not whether or not someone did in fact violate it or did not, but is this an accurate reflection of what we wanted? Is this going out into the community and having an effect in the way we thought it would? Do that all the time with legislation. I've litigated so many cases I can't even count them, and that is always the central question. Is the legislation that was drafted executing in the way that we expected? That's what the audit authority is. It's not adjudicative. It's not complaint-oriented. And so, and I honestly don't see it. Again, you know, I don't see this as a personal articulation of irritation at all, but as an institutional situation wherein a legislative body requests of the executive, not once, a couple of times, I think 2 or 3 times, had conflict counsel speak with the city attorney's office about this very issue, couldn't come to accord on it. And so I would push back a little bit on the question about, you know, did we go to, you know, did one or more members of the commission go to President Travers to talk about it more? You know, at some point, as an institutional body, you got to take no for an answer. I mean, it, you know, particularly in as much as we are representing members of the public that have very little access to the mechanisms of their government. And we are that best access. And so I understand what you're saying about collaboration, but I must, you know, agree with Commissioner Genorio that collaboration takes more than just one person saying please over and over and over and over until someone says maybe. Like, as an institutional authority, we have to assert our authority, not beg for it to be recognized. Commissioner Cox?
So just a couple of points. One is that in like a major use of force incident, like the one that was like from September, no complaint was filed. It was reported on, but it seems to be treated as a lower echelon case by the public. It's not as sexy as some of the other causes that people have joined. And so it didn't get the sort of notoriety that other instances have gotten, and no complaints have been filed on that. As far as I'm aware of, no complaints have been filed. And so I think that, you know, anyway, just to say that there's a difference sometimes depending on what the complexion of the case is. Has there been a complaint filed? Is it been in the newspaper? Is there some public recognition? But, you know, virtually always in a major use of force incident, there's an investigation, but are there different rules that the executive, meaning the mayor, wants to have for different scenarios? And let's work with that, but I don't even know what those are. And so that's just one point. And then the other point is, I think that, you know, the city council is the legislative body, and not us. We don't make legislation. We exercise the powers given to us by the city council and by the charter. And those do not include a date by which we get body cam footage. And so, yes, writing or communicating with the city council might be useful, but wouldn't it be more effective to first have a conversation about it with the Burlington Police Department, who should be our main collaboration partner? That's my position.
Thank you, Commissioner Cox. Is there any other discussion on this matter? Yes, Chief.
Thank you for recognizing me. Just on the September issue, I think it's important to highlight that officer-involved shooting is handled pursuant to a state-mandated use of force policy. So that evidence is turned over to the Attorney General's office for their review. That's an active criminal investigation. We are still awaiting the results of that today. Recognizing the conflict that you've identified with the policy compliance, and, you know, does the commission have more authority than someone on a public records request? You know, I'll let the lawyers figure that part out, but the legislative intent of the use of force statute and then the subsequent policy that came out of that specific to body-worn camera footage was very, very specific as to they didn't want the body-worn camera footage evidence or other related evidence publicly released and you can argue whether or not this body falls within that prior to the investigation being closed.
Sure. Thank you, Chief. Commissioner Janorio?
I guess I just wanted to, I didn't want to cut you off.
Sorry.
To say, like, maybe we are in agreement with some things. In the past, the commission has simply reviewed body cam footage from all use of force incidents to gain a general knowledge of how these things play out. It was not, as Mary said, to undergo any disciplinary actions. And maybe if we drew up a directive or amended some of our policy that stated instances in which we would like to, as an entire commission, be granted access to these things and run that by legal and send it over to BPD, that could start a collaborative process so that we would get some better outcome next time, some faster outcome next time.
Sure, yeah.
Yeah, I was going to say something very similar. I think if we're thinking about what our ultimate goal is for tonight, I love what you were saying about, like, it's an audit. We're an auditing body. And what is our process and what are our procedures that we can expect moving forward in order to be that, in order to do that mission? And so I love what you're saying in terms of writing something, having it be like asserting that that is our responsibility, and then understanding what our next steps are so we can have kind of that like stable process in place so we're not always second guessing.
So, you know, I do understand, and I'm very sensitive to, you know, what I hear from the commission about, you know, wanting to be collaborative, wanting to be less confrontatory. And, you know, I have like put together some language that maybe tonight isn't the time to vote on it, but maybe next time. But I would like to read this language as a thought. And you know, just because, you know, I do think it is important for us to vote on the letter, but, and frankly, I think it'll fail, but I think it's important to vote on it. But I am going to read what I think is some reasonable draft language that I've sent to all of y'all to think about in the intervening month. And it's a resolution that would only affirm the commission's audit and review authority. And it would say, whereas the Burlington Board of Police Commissioners holds authority under Burlington City Charter, sections 183 and 184, to audit and review Burlington Police Department actions for conformity with current department policy. Whereas that authority was affirmed and operationalized by City Council Resolution 7.09 in 2021, which contains no exceptions for categories of records, types of police action, or circumstances under which the Commission's audit access may be withheld. Whereas the Commission exercised that authority by requesting body-worn camera footage of the March 11, 2026 ICE detention and protest, and that footage was withheld from the date of the Commission's request until April 20th, 2026 without a stated legal basis. Whereas the Commission's audit and review authority is meaningful only if it is recognized and honored by the Burlington Police Department and the City of Burlington. Now, therefore, be it resolved that the Burlington Board of Police Commissioners affirm that its audit and review authority under Charter Section 183 and 184 and Resolution 7.09 is a freestanding oversight power that admits no categorical exceptions, and that the withholding of the department records from the Commission requires a specific written legal justification. And be it further resolved that the Commission requests a meeting with the Mayor and the President of the City Council to discuss how the Commission's audit authority will be recognized and honored going forward. So I would ask that y'all consider that over the course of the next month. And I would like to put it on the agenda for next month, because I agree, like, if we can make this a collaborative process, we should. And I would encourage us to assert our authority and what we believe it is as articulated and as discussed with conflict counsel. Yes, go ahead, Commissioner Paul.
So I think that, I mean, if you want to vote on the open letter, we can vote on the open letter. I think that the thing that we can easily do in the month of May is just simply ask the council president to come to our next meeting and have that conversation as a conversation. That way there's no discussion about it being done in private, or that the public would not be aware of what the conversation was. I have a feeling that he would be more than happy to attend and have that conversation. I don't think we need to go issuing resolutions and letters and back and forth, and I just think that there is a way that we can do this in an open way, in a collaborative way, in a positive way, and potentially get the outcome and clarification that everyone is looking for. So, given the hour, I would hope that we might be able, if you want to take a vote on this letter, that we take a vote on the letter, and then if that motion does not succeed, my suggestion would be that we invite the council president to our next meeting in May.
Okay, yeah, we can do that too.
Can I just make a clarification? The intent of having Council President Trivers here is to have a discussion about a policy wherein we are all in agreement when we are to receive.
Well, I'm not sure that that's completely rests with his authority.
Right.
But I think that
so.
if you want to, the resolution was saying, let's have a meeting with the mayor and the council president. You know, I can't speak for either one of them, but I think that there is a way to do that in a more positive way than to just simply have, you know, to have them come to a meeting and have that conversation. I mean, I don't know that we're going to resolve everything in the course of a conversation, but it certainly is a way to get things started in a positive way.
And I appreciate that. I don't see that as mutually exclusive. I think it's completely appropriate to invite, you know, the president of the council and the mayor to come talk about this. I also think it's appropriate to consider the resolution, like a resolution language, if the letter is, you know, voted down. And so I think that's a good idea, Commissioner Paul. Anybody else? No?
I'm sorry, I'm really not trying to be pedantic. I'm just not sure I understand what the discussion is that we're having. It's the discussion of what we kind of are saying in the letter, but we're doing it in face-to-face?
That's my understanding.
Yes.
Okay.
Yes.
And that is preferred for...
I think that's going to have a much better chance of getting the outcome that we're seeking than this approach.
Okay.
And again, I don't think they're mutually exclusive, but I appreciate that. Yes, Commissioner Cox.
I was just wondering, so the chief is right there, and I was wondering if we could ask the chief if he would be open to a meeting or collaboration or discussions with maybe even just a couple members of the commission to see if we can even maybe, like the chief described something tonight that I hadn't really taken in totally prior to this. And so maybe just informational to begin with, and maybe we could discuss where the loose edges are that could be worked on either through city council resolution or if it's really just a state mandated issue. I don't understand all the ins and outs. And so can we ask the chief, would he be open to a dialogue?
I certainly would be, and I think it would be helpful to go through the small number of policies that the commission has in terms of different levels of access and the timetables. And that way they could be really looked at critically to see, can they be more consistent? Do they need wholesale change? Do we just need to add something as it relates to this audit authority in terms of a policy, as opposed to relying on what is clearly opaque charter language at this stage? However I can help, or how the organization can help move this forward in a constructive manner, we're willing to do.
Thank you, Chief. Any other discussion? No? Okay. Since it's on the agenda, I am going to move for a vote on the open letter. Do I hear a second?
I'm sorry, is the vote to publish?
To publish the open letter.
Okay.
Do I hear a second?
Second.
Okay. Commissioner Fast, yea or nay?
Yay, and I also would say an invitation as well for a conversation simultaneously.
Okay, thank you. Commissioner Paul, yea or nay? Okay, I am a yea.
Yay?
Okay, Commissioner Cox?
No.
I'm sorry?
No.
Okay, Commissioner Finneran?
No.
Okay, thank you. That motion does not carry, and we have ended that part of our business. Next, we have commendations, but I don't believe, looking at the agenda items, I don't believe we had any commendations. Did I miss one?
Sorry. No, but as I had mentioned before, pending the outcome of that vote, I would then make a motion that an effort is made, I can leave that to the chair, to invite either the mayor or a representative of the administration and the council president to our next meeting in May, and that item would be on the agenda prior to any other business that is related to this issue.
Okay, I'll second that. All those in favor say aye.
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 Aye. Those opposed, the aye. That's fine. That carries. I will do just that. Thank you very much, Commissioner Paul. Announcement of next meeting date is May.
Chair Dever.
Yes, Commissioner Cox.
Could you designate a couple people to go and talk to?
I'm sorry. I'm having a difficult time hearing you, Commissioner Cox.
Would it be possible for you to designate a couple of people to have a conversation with the BPD as he was describing that he'd be interested in engaging in?
You know, at this point, I'm going to ask if I can just kind of work that out by consensus, not here right this instant, because it's kind of a lot logistically to kind of figure out with the chief and between us. So I'll certainly start that conversation over email and, you know, reach out to the chief to talk about times. Would that be all right?
Yeah, it just can't be the whole commission or quorum
I
that
understand.
meets with them. Okay.
Thank you, Commissioner Cox. Okay, so we don't have any commendations. The next meeting date will be May 26th of 2026. The executive session was taken off, and so I will now move to adjourn our meeting. Do I hear a second?
Second.
Okay, all those in favor, please say aye.
Aye.
The ayes have it. Thank you very much. We are adjourned.